Please rise. The Justice of the Appellate Division, Supreme Court, First Department. He will represent the business of the Appellate Division. Draw near, with your attendance, and shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division, First Department. This afternoon we have some 7 hours of argument time that has been requested. So please keep that in mind as I call the calendar. Remember that we have your briefs, we have your record, we're fully familiar with the facts of your cases. So please ask only for the time that you need to get your most important points across. Okay. And the calendar. First case, People versus Ashambry Briggs. Submitted. Castillo versus TRM Contracting. Okay, 5, 2, and 6. B Children, submitted. Pinson versus Royal Charter. Five, 2, 5, and 5. Tina Turner Musical versus Chubb.
Good afternoon, Your Honor. The felons request 5 and 2. Good afternoon, Your Honor.
5, 2, and 7. Tawapanta versus 1211 6th Avenue.
Request 5 and 2, Your Honor.
Would you repeat that, please? Did you say 3 or 4? Okay, 5, 2, 4, and 3. People versus Boris Brown. How many? Okay. 5, 2, and 6. Burlington Insurance versus Cookman Best Insurance. Um, 5 and 2, 5 and 5. Lively versus Wayfair Investment. Five, 2, and 5. Spence versus Strauss Park Realty. Submitted. People versus Keith Woody. Good afternoon. 5, 2, and 5. 4720 3rd Avenue versus CA Ventures. 5, 2, and 5. Thank you. Tender Touch Health versus Zuneg. 5, 2, and 5. Whitcomb versus Con Ed.
Respondent Con Ed 4.
5, 3, 5, and 2, and 4. Siegel versus Eisen, and by the way, that case is going to be called at the end of the calendar because Justice Gessmer is recused. Siegel versus Eisner. 5, 2, and 5. People versus James Sanford. Submitted. Kaufman versus Boyce Schiller. I'm sorry. Who is the appellant? There's no appellant. Do you wish to submit? Well, I don't know. I see no appellant. Do you see someone there? There's no appellant? Either of you appellants? Okay, so there is no appellant. Do you want to submit? I take that as a yes? Yes. Okay. It's up to you, not my decision. Thank you. Submissions. Yeah, they can, on the last case, they can leave. Yeah. They didn't ask for argument. Am I right? Oh, you didn't hear me. On the last case, there is no argument. It's a submission, so they can leave. Okay, first case for argument is Castillo versus TRM Contracting.
Good afternoon, Your Honors. Seabrooks Johnson for the defendants' appellants in this case. I think, this is not your classic fall from a ladder 240 case that this court has repeatedly awarded summary judgment on. I think the record is littered with contradictions regarding whether plaintiff could fully open the ladder.
Please tell me
Yes.
where the record is littered.
Okay, I will start with the affidavit of Mr. Samarco, who came to the accident scene right after the accident, and he said based
Okay,
on...
does he provide any details other than his conclusory statement that there was enough room? Does he tell us how many boxes were there, how close they were to the window where the plaintiff was working? Any details that would support his conclusion that there was room for the ladder?
Your Honor, I would say he does not provide excruciating specific details.
He doesn't provide any details.
Right, but neither does plaintiff, Your Honor. And I
Except that plaintiff is, okay, you've admitted now, I guess, that the person who comes and takes a look, Jamarco, does not provide any details other than he just says he didn't see the space.
No, I haven't admitted that at all, Your Honor.
What did you just say? I just want to be clear.
I'm saying he went to the accident scene immediately after the accident, and he said based on his observations of that room, he's on site every day, that plaintiff, when he was lying on the ground immediately after the accident, had plenty of room to open the ladder.
Okay, he didn't do any, he said, in other words, he just made a statement, he had plenty of room.
Right.
He didn't open the ladder, he didn't do any foot tests to see, 1 foot in front of the other, he didn't get a measuring tape. Okay.
Sure,
Now,
sure.
You just said that the plaintiff didn't either.
Right.
The plaintiff had been working in this room.
Right.
The plaintiff had been opening his ladder on
Right.
every other place that he worked.
Sure.
The plaintiff opened the ladder there or attempted to, and he couldn't do it. So, and then he kept the ladder closed. He
Okay.
was opening the ladder the entire time. So in this instance...
Wait, hold on, Your Honor. I'm sorry. You said plaintiff was opening the ladder the entire time?
Plaintiff had worked, that wasn't the only space that the plaintiff had worked in. The plaintiff had been working in the area with the ladder opened. He couldn't, in that particular area, open the ladder, so he kept it closed.
That's what he says, right.
Okay, so you say that he said the same thing, but his is a more contemplative review in that he's the one who was working there. He's the one who was opening the ladder.
Sure.
He could not open the ladder.
Sure, that's what he says.
What?
But I guess my point is is if you're going to hold my client to the excruciatingly specific standard of him having to do measurements, of him having to show the dimensions of the room, plaintiff's testimony, he's asked repeatedly, how large are the boxes? I don't know. I didn't measure
Well,
it.
counsel, let's talk about the coworker, because the coworker
Right.
also indicated that it was impossible to place the ladder where it needed to go in an
Sure.
open position
Sure.
because of the boxes.
Right.
I didn't see anywhere in the record
Sure.
that was contradicted.
Your Honor, I think the video that plaintiff submits, I mean, I know it's a 2-second video, but you look at it.
It doesn't even show a window, so it does not
Right.
show us the area. These men were tasked with taping up the windows,
Right.
so that painting could happen without messing up the windows.
Correct,
right?
but I also, to that point, plaintiff's the movement on summary judgment, right? It's his burden to eliminate all issues of fact. The video does not show, also the area where he works, the specific area by the window and the floor, but it does
So
show.
then it's irrelevant.
No, it's relevant, Your Honor, because he contradicts himself because plaintiff testifies that the room is full of boxes, right? The video doesn't
He doesn't
show
say the
that.
room
doesn't
is
say
full
that.
of boxes. He said that there were boxes in the area, in the room. He was told not to touch them. He was told they didn't belong. They didn't belong to who he was employed by. And he says, and they were too heavy anyway.
Your Honor,
and he was able to use his ladder in the open position earlier. He had been on and off the ladder, so boxes weren't everywhere.
Your Honor,
When
I mean-
he went to this particular place to cover that window, that's where he could not open.
Your Honor, on rebuttal, I can show you the exact site in the record where plaintiff says the room is full of heavy boxes, okay?
Look, what does that have to do with the, when you say, I guess I should ask, when you say the room is full of heavy boxes,
Right.
what does that amount to? What are you saying?
I'm saying that plaintiff testimony is all over the place in this case, okay? And I also think, not to lose sight of the fact that plaintiff is saying also, this goes to the prematurity argument, that the foreman
I'm
wasn't
glad you
there.
brought that up, because I'm not sure how is it premature when plaintiff was
Right.
deposed. You also had an affidavit.
Sure.
In opposition.
Right.
You had- The employer certainly didn't present any opposition.
Right.
So please tell us.
Yes.
How it was premature.
Okay, so number one, plaintiff's employer is not under my control, okay? I can't compel him to give testimony or to give an affidavit, okay? Number two, plaintiff's...
Let's talk about the plaintiff was deposed and you had that affidavit. Let's
Right, I
talk
had the
about
affidavit from my client, I hadn't have the affidavit from Freddie, okay? But Freddie now has been deposed, okay?
But counsel, we can't consider Freddie's deposition because that's not in the record. You filled your reply brief with that, which was totally inappropriate. So we're not going to talk about the substance of that deposition because it's not before us.
Okay,
But what I want to ask you about
Yes.
that is, you said in your papers, and I thought maybe it was persuasive, that this was premature.
Right.
Because you had asked for Freddie's deposition. And there's nowhere in the record that shows that you ever noticed that individual's deposition. There was discussion about when to depose a representative of the painting company.
right.
But never, I could not find anything that shows that you either noticed Freddie's deposition or that when you were emailing with your colleagues
Sure.
about when the deposition should be, nowhere was it specified that they produced Freddie. So I don't see that you ever asked for that.
Well, we did ask
Can
for
you
the...
show me where in the record you ever asked for Freddie's deposition?
I think you may be accurate in saying that we never asked for Freddie's deposition.
you.
But we asked for the foreman's testimony, and Freddie's the foreman.
I did not see anywhere in the papers where it said the foreman's deposition was requested. Perhaps before you reply, you can find that.
I will look for it.
Good, because I couldn't find it.
Okay, thank you.
Thank you.
I can breathe again. Good afternoon, Your Honors. Jonathan Dax, representing the plaintiff respondent.
Counsel, we have a case here where the plaintiff was on the ladder, he's using it in a closed position. He says that he's blocked by boxes and he couldn't open it. We don't have any measurements, we don't have any photographs, we don't have any issue, and we have this Mr. Simanko, I believe, who says that there was enough room. What do we do with that?
Well, I think Your Honors made several of my points on the questioning of my counsel adversary here, but I don't want to take anything for granted.
That's a good idea.
Yes. What you have from Mr. Samarco is completely different from what you got from the plaintiff. The most important thing that the plaintiff did that Mr. Samarco didn't do and could have done if he wanted to was attempt to open the ladder. Mr. Samarco did not indicate in any way that he knew exactly where the plaintiff was working and needed to reach to get to the window. Plaintiff knew that. He was doing it, as you said, most of the day. Mr. Samarco, I mean, it's true, plaintiff did not make
Did Mr.
measure.
Samarco ever indicate that he took a photograph of the area, since everyone I know has a cell phone?
He did not. There's nothing in the record to that extent. The only photograph, which is actually a 2-second video, as the court is aware, was taken by by the plaintiff's coworker. It only shows a very narrow area. It shows a clear wall, but that's not where anything was taking place on the wall. It was taking place in front of the wall, to the side of the wall, near the windows. So that video really, I know plaintiff submitted it, but it doesn't help either party. It's irrelevant. Again, Mr. Samarco, he talked about statements that he made, instructions that he gave to other workers at the scene. Never mentioned that he gave any such instructions to the plaintiff. And in any event, advising people not to do certain things that might be dangerous is not, court has found many times, not a substitute for a valid and proper and properly placed safety device. What you have here is a safety device that failed to keep the plaintiff from falling. It is a classic 240 case. This court has decided many cases involving A-frame ladders that are being used in a closed position, and time after time, I did research last night once I knew who the judges were sitting today. All of you have been on cases that hold the general principles that should preside here, which are that an unsecured ladder, even if it's not defective in any way, can lead to a violation, a finding of a violation.
And this one was, right?
I'm sorry?
This ladder was.
This ladder was unsecured.
It was in poor condition.
It was in poor condition.
It was in poor condition.
And we have an affidavit from his coworker who corroborates that.
Absolutely.
And no one submits any statement about the ladder being okay.
Correct. There's no refutation of any of the allegations of problems with the ladder. And maybe the most important is that it was unsecured, and the failure to secure it is not to be held against the plaintiff. Any argument that there was no defect in this ladder are incorrect. I do want to take a minute before I get the red light to state my protest. Your Honor alluded to it earlier. The references in the reply brief to Freddie's testimony is kind of outrageous, completely improper. It's matter dehors the record. It's the definition of matter dehors the record. And counsel's statement in the footnote that this court can take judicial notice of subsequent testimony in the case is about as flagrant a violation of the rules as I have seen in a long time. So certainly no involvement of Freddie's testimony should be in this case.
Was there anything in the record that showed that defendants had actually requested the testimony of Freddie or of the foreman?
I don't recall seeing any such thing. I know they never requested Freddie. They should have known who Freddie was from the very beginning. I don't know what efforts they made. Even if they did serve a notice for the foreman, it's not clear that they put any great emphasis or effort into making that happen. I would also note that the testimony by Freddie was on April 1st of 2022. The brief in this case, initial brief by the appellant, was filed May 20th of 2022. If counsel really wanted to get Freddie's testimony in, there's lots of things he could have done into this appeal and not have to worry about the next appeal, but he didn't do any of those things. He didn't seek to supplement the record, which would have engendered my objection. And just gilding the lily a little bit, to submit that information in a reply brief when I have no opportunity to respond to it is terribly unfair. So under those circumstances, I respectfully request that the court affirm, and for all the reasons stated in the brief to which I refer.
Thank you.
Thank you very much.
To Justice Gesmer's question about whether we specifically requested Freddie's testimony, I cannot tell, based on the information I have, whether we did. I trust that if we requested a deposition of Park Avenue Payne. I can't say that it was specifically Freddie. I don't know. Regarding the defect of the ladder, plaintiff said the ladder moved to the right. He didn't say that, he used the ladder.
Said it was wobbly, shaky, that the feet didn't move,
Yes.
and so did Marciello.
Yes, I agree.
Pronouncing his name right.
No, I'm not quibbling with the ladder being defective. I'm quibbling with his testimony saying that the ladder moved to the right, that it didn't wobble, shake, or any problem with the ladder didn't cause his accident, right? Because Labor Law 240 still requires a proximate cause analysis. So if there aren't any more of the questions, I will rest on my brief. Thank you.
Thank you. Thank you both. Penzon versus Royal Charter.
Good afternoon, Your Honors. Fred Friedman for Appellant.
Good afternoon.
We have two A-frame ladder cases in a row, so I'll just say that ours also is not an atypical one. I think we explained it in our brief, but it's almost the same exact set of facts as you had in the Marino case, which the defendant cited the trial court decision, and then obviously this court overturned it. It's a pretty typical set of facts. A plaintiff has an unsecured ladder. It moves. He falls. He doesn't have to show it's defective. That's enough for our burden. Defendants are the ones that have to raise the issue of fact, and I think what they did in this case is kind of throw everything they could at a wall hoping something would stick. But at the end of the day, nobody actually refuted what plaintiff said happened. The ladder moved, he fell, and he specifically said he fell to the back. It's kind of striking that they have an expert who doesn't once address that. So there's really no difference between our case and a very long line of precedent from this court on 240. Happy to answer any questions.
You have some rebuttal if you want to wait till then. Otherwise, if you have nothing else, we'll...
Okay, thank you, Your Honors.
Good afternoon, Your Honors. Scott Pearl for Respondent, Royal Charter. I will be very brief and just address appellant's issue on whether or not it was refuted or we established that there was contradictory testimony, and I would say directly received from the plaintiff, which calls into question and raises an issue of fact here. Mr. Pinzon testified that he's an experienced worker. He had an A-frame ladder in a hallway, a corridor that he was familiar with, in a building that he had worked in before. He described actually placing that ladder 1 foot from the wall.
He was plastering, right?
Plastering.
Okay, let's go from there. He's on the ladder.
He's on the ladder. He had placed all 4 legs of the ladder in contact with the floor. He placed the ladder 1 foot from the wall in order to do his work, and he described that the wall to his left, from when he was on the ladder working, was 5 feet away. He describes that while working, the ladder does not go back. He repeatedly talks about the ladder falling to the left, falling to the side, and he says that numerous times throughout his deposition. He says that the ladder falls, he falls to the ground, he falls to the left, and the ladder falls upon him in the open, locked
So how did
position.
the ladder provide him with a device that kept him from harm? It did not do what it was supposed to do, right?
Well, Your Honor, I would submit that I think there's a question whether the accident even happened based upon the strong controversy surrounding plaintiff's own testimony.
So, okay, you're saying you think the plaintiff put himself on the floor and then toppled the ladder on him? What do you mean, the
I
accident?
don't know, Judge. It was an unwitnessed accident.
Well,
Just-
okay, the fact that it was an unwitnessed accident is neither here nor there.
Agreed.
The plaintiff says that he fell off and he's on the ground. The ladder is supposed to stay where you put it. It's not
Understood.
supposed to fall. If it was tethered to the ground, nailed to the ground, I don't know, placed to the ground in some way where it wasn't moved, if there was somebody else holding it so that it wouldn't move, maybe it wouldn't have moved. But
Your Honor.
he's doing his work, he falls, the ladder falls, or the ladder moves and he falls.
Correct. As he alleges, but he alleges that there is a distance between him and the wall to the left of 5 feet, that the ladder and he fall to the left. He repeatedly says that, and he says that the ladder falls in an open, locked position upon him. We established through
The ladder doesn't have to be
measurements.
defective. You're
Not
not
possible.
The ladder doesn't have to be defective for there to be a 240.
Understood. Understood. What I'm saying is his very version is physical impossibility. If we
But
look
you
at the
have nothing to
photographs-
contradict it.
I really don't see that at all. I don't see the relevance of any of that. The bottom line is this is a ladder that is not secured, and you have a worker who falls from it.
But, Your Honor, he testifies that the ladder falls and falls with him and falls upon him. We demonstrated that that is physically impossible. Not a discrepancy. And I understand that this court has ruled in cases where defendants want to say there's a discrepancy. Was somebody on the third rung? Were they on the fourth rung? Were the planks a foot apart or 2 feet
I think
apart?
the argument that it is physically impossible is such a stretch. And I don't know what expert could ever say that on these facts.
I think it's demonstrated in the expert affidavit of Mr. Kravitz and the photographs that are submitted, Judge.
Counsel,
Yes, Your Honor.
you put a great deal of weight on the measurements of the hallway and
Yes.
the distances, et cetera, set forth in the expert affidavit. You also put a great deal of emphasis on an alleged contemporaneous entry when he reported to the supervisor, and it was recorded on the very day of the accident that he allegedly fell off the stairs. That was one of your key points.
Just another point of inconsistency.
No,
Yes.
but it seemed to be a big one, because you're talking about inconsistencies. Now, so it could be that an understanding of stairs versus ladder, with the Spanish word having dual meanings, or...
Escalera, let me help you. Escalera.
Right, okay.
Yes.
Thank you. And maybe an understanding of 5 feet versus 5 inches with Spanish. I'm just saying that it seems to be that you're focusing on semantics.
I don't think there's semantics, Judge, because I think...
And your third point,
Yes, sir.
where our appellate case law does not mandate that someone has to immediately get medical treatment right after an accident to somehow vitiate the whole point that an accident occurred.
I don't think that was
Wasn't
not
that your
intended to
third
be the
point?
point. It's just a factual fact of the case. But just to answer that one question, sir, on the stairs and the issue of whether there was a confusion over the language, these are two individuals, the supervisor and Mr. Pinzon, who communicated only in Spanish.
Well, counsel, I want to go back, because if
Oh, I
I
gotta
heard you
hit that one.
correctly, I thought you said the purported accident, but clearly, the plaintiff reported the accident to the supervisor, who did not witness the incident, and that supervisor prepared an incident report.
Yes.
And I just want to go further with this, because it's my understanding that the plaintiff's own supervisor testified that he had no reason to dispute the plaintiff's account of the accident, or even contradict that he used the ladder incorrectly. I think that's in the record.
It is in the record, Judge, I will agree. But he also indicated he had no information, no personal knowledge of it, because he wasn't witnessed, and he was solely taking the plaintiff at his word.
And we already know what the case law says about that.
Yes, we do. Yes.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. May it please the Court, Irina Kravchenko, I represent third-party defendant respondent Cushman and Wakefield in this appeal. It is Cushman's position that the Supreme Court correctly denied plaintiff's 240 motion for summary judgment. The Court of Appeals recently dispelled the superstitious notion that of a ladder moving for no apparent reason. In Bunksar versus American Multi-Cinema Inc., 38 NY 3D 1023 in 2002.
That's a Fourth Department case, I'm pretty sure, and our cases are different. We don't have to follow the Fourth Department. We have enough case law here in the First Department.
Your Honor, I'm referring to the Court of Appeals hearing the appeal from the Fourth Department in that way, in that case.
But the Court of Appeals dismissed that case on other grounds, not on the grounds pertaining to this.
Your Honor, one of the holding was addressing whether the order was reviewable. The second portion of the order held that a rational trier of fact could have found the defendant's favor on Labor Law 240 in that case. So
okay, that sounds like dicta to me. What it was that the case was not properly before the court because it wasn't final. That's what the Court of Appeals held.
Your Honor, it is Cushman's position that that was part of the holding that they did not address the summary judgment order. However, they did address the trial, the verdict at trial, having been reached in defendant's favor on the 240. And if the jury is able to opine and determine whether plaintiff was a sole proximate cause on those facts, that the same concept applies in this case. The issue should be before the jury in this case. So the facts of Bunksar was plaintiff had climbed up and down the ladder, that had no prior issues, had no issues with it, and then when he began to descend the final time, it shifted and wobbled and causing him to fall. This is exactly what happened in this case, unlike actually the first case that was argued before earlier.
That's not what happened in this case. In this case, he went up the ladder that was unsecured and had to stretch his body in order to tape the window, thereby causing the ladder to shift.
Your Honor, it is...
We've had plenty of cases just like that. And the Court of Appeals has said a worker should not have to contort their entire body to accomplish their work on a freestanding ladder.
Your Honor, I respectfully disagree only to the extent that in this case, the plaintiff contorted his body. That was his decision to climb too high. It's not because the ladder was not necessarily in proper protection. We don't know.
It had nothing to do with the top of the window being high and him having to cover the sill of the window, window frame.
He was working, our plaintiff was working on the ceiling. I think, the other cases, facts, our plaintiff was working in a hallway on the ceiling. He was climbing up. He did have to reach it, I agree. However, he didn't have to go all the way up and contort his body, and as he indicated in an affidavit attempting to cure his testimony.
Does the record tell us how tall this gentleman is?
Yes, it does. He is 5'5", 5'6". This was a 9-foot ceiling. He's on the 5th rung of the ladder.
Of a 6-foot ladder.
On the 6-foot ladder, exactly. He could have been on the 4th rung. That's exactly why.
Well, it depends where on the window. I'm assuming the window is at least 36 inches wide.
Your Honor,
which would be 3 feet. And if he has to stretch over in order to tape the middle part of the window or just beyond that, that has his body hanging over the side of the ladder.
Your Honor, the facts of this case actually involved the ceiling that he had to reach up towards, not a window. I'd also like to point out quickly that the plaintiff, in order to obtain summary judgment, was required to show that another safety device enumerated in the statute would have prevented the fall.
And scaffolding would have been nice here, right?
Your Honor, actually, this is 3 feet wide hallway. That's exactly to my point. And Justice Tom, in a dissenting opinion that was recently also reviewed by the Court of Appeals in Kuteya versus Board of Managers, 38 NY 3D 10.
Yes, that one dealt with there, the court, I was on that case, and there the court was dealing with whether it was the ladder that was a problem or the fact that the gentleman was electrocuted and thereby thrown off the ladder by the electrocution. So the court held that there was an issue of fact as to that, but did not hold anything with regard to the ladder.
Your Honor, I see my time is up. May I answer your question?
Yes.
The facts in that regard are distinguishable, but I'm referring to the specific issue of the availability of the other safety device that Justice Tom discussed in the dissent and the Court of Appeals.
Was there available other safety devices here?
Your Honor, there is absolutely no evidence that any of these devices
the evidence here shows that there were 6 ladders by the plaintiff's employer. 4 of them were 8-foot ladders that were being used by other workers, and there were only 2 6-foot ladders left used by the plaintiff and his co-worker. That's what the record shows.
Your Honor, the 6-foot ladder, it is our position that the 6-foot ladder was adequate, it was stable, that there is no indication that other safety device could have been feasibly used in that hallway or that they could have prevented the accident. Unless the bench has any other questions, I will rest on my brief.
Thank you.
Your Honors, I'll be quick because I think your questions pretty much hit the nails on the head. I'll run through this as fast as I can. Bonksar, we already know. Court of Appeals didn't even get to summary judgment. It wasn't the question before them. And your questions about whether the plaintiff fell off stairs or whether he got treatment, again, it's grasping at straws. I think everybody knows that plaintiff fell from a ladder here, not stairs. Their expert never once said plaintiff did anything wrong. Zero evidence, admissible evidence of sole proximate cause here.
And did anybody on behalf of the defendants say that this accident never occurred and the plaintiff had made it up?
I think their expert tried in some way to say that based on the dimensions of the hallway, the ladder could not have fallen over to the left.
Well, I understand he said that, but was there any statement by anybody that they submitted saying that the accident never happened?
Admissible evidence, none whatsoever. I think that's the position that counsel takes, which obviously isn't evidence. Nobody's denying this plaintiff didn't estimate or state the dimensions of the hallway correctly, and this court's already addressed that same type of argument. I think it was the Distowitz decision. I probably butchered the pronunciation, but there was zero testing, zero admissible evidence that what plaintiff said happened, never happened, or couldn't have happened. So it's a straightforward 240 case. If there are no other questions, I'm resting on the brief.
Thank you.
Thank you.
Thank you all. Tina Turner Musical versus Chubb Insurance.
Good afternoon, Your Honors. If it pleases the court, my name is Owen Caraher. I'm attorney for defendant appellant Chubb Insurance Company of Europe.
Counsel, this case involves an exclusion where the language in it, you're asking us to find against the Tina Turner Musical.
Correct, Your
In
Honor.
that you're saying that you've established that the exclusion applies, but how is that so where the language of the exclusion here deals with national and international exclusions, and this theater closed after the March 12th statement by the governor at the time?
Well, I think there's a
Executive
couple.
order, the March 12th, I think it was an executive order by the government, which is not national or international. And you have to prove this, of course, by clear and unambiguous language.
Correct, Your Honor. Let me try and address that in a couple different ways. First of all, the exclusion itself, the way it's written, makes very clear that it applies to any communicable disease or threat or fear of a communicable disease. Then what it does is it moves on
But that's what it does. Okay, I'll let you go on to the, okay.
What it does is go on to define the kind of communicable disease that is contemplated by the exclusion. And that's the language that refers to either a national or international body that imposes a quarantine or a restriction. So
But I think by saying that, you're saying that communicable disease is definitional. And I don't think that that's the way it's used there.
No, if I could just address that point, Your Honor, I'm not saying that communicable disease itself is definitional. What I'm saying is the language that you're pointing to about the national or international orders is definitional. It defines the scope of a disease so that you're not talking about something that's very simple, like the common flu. What it's dealing with is something that's a systemic communicable disease. That's the kind of disease that the underwriters wish to distinguish.
Why wouldn't subsection 1 and subsection 2 be part of the condition precedent?
I'm not sure if I'm following you, Your Honor,
In other words,
but if I could...
You're saying that just the existence of a communicable disease in and of itself meets this language.
No, what I'm saying is the existence of a communicable disease that meets certain criteria.
Right,
and that's
which
the
leads,
criteria that-
according to the language here, it says which leads to, right? Either one or two, correct?
Yes, Your Honor.
So do you agree that either one or two have to be met in order for this provision to operate?
Absolutely, but let me be clear about what I'm saying to you. One or two has to be met, and they're met many, many different ways.
Well, that's for us to decide and for you to
Correct, Your
argue.
Honor, but if I could just make this one point before we move off of it. What that doesn't do is create a second kind of causation. There's no double
It's not
causation.
a question of causation. It's a question of you have to, based on the language in the policy, there
Correct.
has to be a communicable disease.
Correct.
Or fear of one.
Correct.
Which leads to either the imposition of a quarantine or restriction of movement
Correct,
by an international body or agency.
Correct.
Or
correct.
any travel advisory or warning being issued by a national or international body or agency.
Absolutely correct, Your Honor, and all
So
of
how
those have
have
been
you
met.
met one or two?
We've met one or two in many different ways. We've laid out at great length travel restrictions and warnings from the World Health Organization. the
But
European
counsel, this
Union.
specifically is narrowed by the fact that you say imposition of quarantine or restriction in movement of people by any national, that's not the case here, or international body or agency. This particular theater was closed, was left open, despite all of these other provisos that were given before it. This theater did not close until after the state executive order.
Well, I understand
in
that, Your Honor, but implicit in that is a suggestion that somehow or another it wasn't going to close regardless. The world was
It
shutting
didn't.
down on
It
that day.
didn't.
Well,
It didn't.
I think it would be
It didn't close when there were travel restrictions before it. It didn't close when there were national orders before it. It only closed after the executive order.
But here, I'm sorry, Your Honor.
I think you know
But
what I'm going to say.
here's the point I'm trying to get across. There is no causal relationship between the orders that are used to define the communicable disease. 7.211 and 2 are not causation elements. They are definitional of what kind of communicable disease is excluded.
So if they are
orders then
definitional,
help to
why weren't,
establish-
I'm sorry.
I'm sorry.
If they are definitional, why weren't they included in the definitions section like the definition of terrorism was?
Well,
Is.
look, people write things differently, and
Well, I
that doesn't
understand, but you
necessarily
wrote,
mean
your
that-
client wrote this. So we have
Well,
to.
actually, it's not in the record, but you could see directly from the paper that it's not Chubb that wrote this. This is on Breton.
But that doesn't matter, because you can't come here and say, oh, it's not in the definitional section, that's not our fault. You have to show that this is clear and unambiguous. And this does not show that it's clear and unambiguous when you've got to explain to us, oh, it wasn't in the definitional section because of X, Y, and Z, but it really is definitional.
Well, to be honest with you, Your Honor, I was just trying to respond to your questions. I believe it is clear and unambiguous because it says we exclude a communicable disease which leads to events that actually happened.
Yes, but then you
unquestionably
didn't
happened.
answer, yeah, but if it's, the point was, it's not definitional. Otherwise, it should be in the definitional section.
I don't think that there's
was
any
the-
requirement. I'm sure Your Honors have seen policies over and over again where there's some terms that are defined and there's many other terms that are defined by the context.
No, actually, when that happens, that's how you end up here. That's what happens. When the contract is not written properly or as precise as it could be, you end up here.
Well, if I might say, Your Honor, the fact that somebody else, like yourself or like me, might have written this exclusion differently doesn't necessarily render it
Except,
ambiguous.
sir, you work for an insurance company, and at the end of the day, it is your company that issues the policy. So you're stuck with the language you agreed to.
Well, if I could make one point, I see my time is up, but just to respond.
And I
to what
think
your
there's a
point-
question. Okay, let's ask that question.
The bottom line here, we have an order that was issued in response to a virus, state and local, not national, not international, and it wasn't the resulting disease, it was the state's response to the virus.
Well, if I may, If the question, the way you're presenting it to me, is that you believe that the governor's order has to be the causation of the loss, which is not what I believe that that clause says, because if it was to be read that way, you'd have two different separate causation requirements in that exclusion, and it would have been written completely different if that's what they're looking for. The exclusion would have been written to say, we're going to exclude loss from an order of a certain kind that results or is issued in fear of a
You would have
pandemic.
been fine if there had been no mention of national or international.
Well, except that I think
It was the choice to put that language in that now restricts the orders we can look to say that this applies.
well, if I may, there's two other instances that we found published in the world dealing with an exclusion that looks to define the communicable disease or explain it, provide the parameters to it in a way similar to here. First is the Outback decision, which
Wait a minute,
referred to you in Australia.
that's decided under Australian law, which is actually not relevant to our decisions most of the time.
Well, its analysis of the clauses is exactly the way we went through it here, and it was published after this was briefed and decided in the trial court.
But the decision doesn't make clear whether Australia interprets exclusions as narrowly as New York does.
I believe it did, Your Honor. I believe it explicitly said that they have to be defined narrowly. But there's also the case from Illinois Federal Court, I believe it's Ridgeway, I may be misremembering the name a little bit, where there was a Lloyd's of London policy, where there also was a communicable disease exclusion, and there they said that the exclusion applied to instances where the World Health Organization had issued certain orders. It was very similar to here, and the federal judge sitting in Illinois looked at it and said, while I think this was a poorly written exclusion, it's clear what they were doing. They were defining, just as the Australian court did and just as we're suggesting, that the language about the orders and the travel orders and the restrictions is definitional, or another way, it triggers the communicable disease exclusion.
Thank you.
It makes clear when it applies.
Thank you. You have some rebuttal.
Thank you.
Going.
Good afternoon, Your Honors. Alex Hardiman for Tina Turner. I think this is best summed up by Chubb's claims person's denial of this claim. The Chubb claims person, when first denying the claim, wrote, as coronavirus is classed as a communicable disease, the exclusion would be applicable, and therefore there would be no cover under the policy for the actions taken by the US government in closing the theater. Tina Turner immediately wrote back and said, hold on, there's no US government order here. Number one, there was no US government order. And number two, there was certainly no US government order which closed this theater. It was
So doesn't that communication tend to support our perception of the plain language here, that they thought a U.S. government order was required?
It does, Your Honor. And that is why Tina Turner wrote back saying, oh, we're fine here. We have coverage because you've misunderstood. There may be a UK order, because this came from a UK claims person, and there may be a national UK order governing coronavirus there and closures in the UK. But in the US, for a US policyholder, in this instance, there was no national order which closed this theater. What closed the theater was
The executive order of the governor that was
the
in.
executive order of the government, exactly, Your Honor. So, and sort of running as a theme throughout the briefing by Chubb here is trying to place this in the context of, oh, well, this is COVID-19. We all know all of these COVID-19 decisions have been rejecting coverage. But all of those COVID-19 decisions are property policies, and they deal with business interruption for property policies which require physical loss or damage. No requirement of physical loss or damage here. All you need is any risk, and the only exclusion here was for a closure relating to a communicable disease or losses, coverage for losses that arise out of or are contributed to by a communicable disease
Which leads.
order were issued by a national or international body. And with respect to the Outback case, absolutely Australian law not applicable here. the decision did not make clear that at all that it has the same coverage law that New York has. Indeed, I'd be surprised, given the fact that it derives from primarily English law, that it did. And in that case, there were significant distinguishing factors. It's interesting that the insurer in that case, in fact, did not adopt Chubb's argument here. They focused on, well, is the order here in Australia, is it a national one or is it a local one? And that was the predominant focus of the court in Australia. Is it national or international order? It found that a national body in Australia had issued an order, which in turn, the insured there had voluntarily closed. And so it found that, yes, the national order, based on the minutes of the policyholders' meetings about the closure, they decided because of the national guidance and travel advisories, they were going to voluntarily close. So there were all sorts of facts there that were different in any event. And I would submit on that unless the court has any other questions.
Thank you.
Thank you, Your Honors. If I may, there were a couple things I think that were said there that I don't believe are accurate. First, and by the way, I misidentified the case before from the Illinois federal court. It's Radiological Society of North America,
I didn't find it.
where the federal judge was addressing that. First, Your Honor, you raised the question of whether or not the disclaimer letter
But just to point, because you did just just point out that it was radiological, that case only talked about arising from communicable diseases. That's the only thing it said in that case, in the radiological case.
Yes, Your Honor, but that's, I'm not sure how that's a distinction here. The question there was, how did you interpret that exclusion?
Because here it's limited, as we've been talking about, by national and international, whereas in this particular case, it was a state executive order.
If I can, the Illinois case was triggered by a quarantine advisement from the World Health Organization. So my point was that that was another example.
Which is an international organization.
Which is an international organization.
So if that had been the case here, we wouldn't be here.
Well,
But what we're dealing with here is the governor's executive order, a New York State order, not an international, not a national. So how does that satisfy the 1 and 2 or 2 in this provision?
Governor Cuomo's order is actually irrelevant. The question of whether or not an order closing down a premises...
I don't see how that argument helps you, counsel, because until that order, as my colleague has pointed out, the theater remained open.
But time and time again, other litigants have come before courts all around the United States, this court, federal courts, and they've argued, yeah, there was COVID-19, but I didn't shut down until some government shut me down. And courts have routinely, and in fact, we've cited, I think, 5 or 6 of them from your colleagues downtown, the federal bench, where they, one of them's titled 100-something, I'm forgetting the name, that repeatedly found that the causation element was the disease, not the orders. But here's the important thing, Your Honor. This exclusion, when you read it, says nothing about how the order, it has to cause the loss. It says it excludes losses from coronavirus, which lead to certain types of orders. And here's the important point. The types of orders that were required to trigger this exclusion all happened. There's a long list of them that are listed in that exclusion. So the first question is, was there a coronavirus? Did it cause to a loss? And did that kind of coronavirus trigger certain kind of orders? And that has all happened and is abundantly demonstrated here. And by the way, is not disputed. So the real distinction here is to make clear there is no second causation trigger in that exclusion. There's only one. That's coronavirus. And everything else just helps define the parameters of what kind of communicable disease will trigger the exclusion. Thank you, Your Honors. If there's no other questions, I'll defer.
Thank you. Thank you both. Tawapanta versus 1211 Sixth Avenue.
Good afternoon, Your Honors. Brian Isaac, I represent the plaintiff appellant. Our position in this case is that given the force that the door could have, even over a short descent, this is a perfect 240 sub 1 labor law case based on your decision law dealing with cases of those type, all emanating from the runner decision.
But counsel, when you talk about the size of the door, isn't there a huge dispute about that, whether it's 100 pounds or 300 pounds?
No question about it. There is a dispute
So
as
your
to...
claim is that if it was only 100 pounds, well, I don't understand why that dispute isn't germane. Because if it's a question of whether you have to lift a 100-pound door up to the level of 3 feet, which is what the defendants claimed, or whether you have to lift a 300-pound door up to 7 feet, it seems to me a very different thing.
Well, let's talk about that, because there clearly is a difference. And I can't sit here and tell you with any degree of candor that 300 pounds is the same as 100, it's 120 pounds.
Right.
But I do want you to focus on a couple of facts that I think are undisputed. First, no one denies that actually three people were sent to do this job. It wasn't a one-person job, it was a three-person job. Clearly, the Italian...
I have to ask you, as you're answering this, could you please explain how this case differs from the Natalie case?
Sure. So
Because in Natalie, it seemed like there was a question of fact. It went to the jury. Then on appeal, we said, fine. But in that question of fact, it was, I don't think I need to tell you the rest of the facts, it was too light. And they said that, well, the jury said no, given the size, the this, the that, it required some hoist.
So let me try to address that. And I have a different site that I'd like you to look at. Again, one of your cases, but it's a post-Natalie case. It's in the brief. It's Gutierrez against 610 Lexington property. It's 179 AD3D 513, First Department 2020. And as you know, Justice Renwick, the Natalie case, I think, was a 2017 case. So let me answer legally, and then let me answer factually as well. The thing I want to say, and I don't want you to laugh at me, is a door isn't a barbell. It's not a dumbbell. The weight that's involved is not simply something you're lifting up. It's also the configuration of it. So let's assume that you throw out what my client says, because it's a summary judgment case, and you take Mr. D'Amico's claim, which is that the door was 100 to 120 pounds, 7 to 8 feet tall, and 36 inches wide. That's a big door. When the plaintiff said, I couldn't carry it, it was too heavy, there's nothing wrong. No one said he could have done it. Now, Mr. D'Amico said it might not have been heavy enough to actually raise, but again, we're talking about a cumbersome object that's very, very hard to lift, even under Mr. D'Amico's version. And if you look at your decision, and by the way, there's no claim that there was a recalcitrant worker. There's no claim that plaintiff was told not to operate this way. There's no claim that only the plaintiff was supposed to throw this. There's no claim at all about that. In the Gutierrez case, you said, and I'm quoting, summary judgment was properly granted to plaintiff on his labor law 241 claim where he was injured when, while being passed a heavy concrete form from workers on a scaffold above, he was unable to control the form's descent and fell backwards. Here's the part of the case that I want you to focus on, because it's directly responsive to Justice Gesmer and Justice Renwick's argument. Quote,
Question. We don't make arguments here. Question.
Questions, I'm sorry, I misspoke. Quote, even if, as claimed by defendants, plaintiff was receiving a higher sheet of plywood form cover rather than the heavier rubber covered form, it is irrelevant because under either version of the accident, liability lies. Now, in Natalie, we're not dealing with a large door that's large under anyone's configuration of the evidence. From my reading of the case, you were dealing with a skid. A skid's a lot different than a door. We don't know from the decision what the weight is, but it seems to me that a 100 to 120-pound object, which, by the way, severed the plaintiff's fingers on contact. This isn't a situation where the plaintiff had a hand injury or bruise. His left index finger was severed on contact. It's proven in all of the accident reports. It's set forth in all of the testimony. It's not disputed. So
So you're saying we should render the factual decision here based on not just the weight, but on the fact that it's 8 feet or it's whatever, and the fact that it severed his finger? Those things are not factual decisions for a jury. They are for us to render?
Yeah, what I'm saying is that under either version of the accident, take the plaintiff's version or take the defendant's version of the accident, this is a 240 sub 1 case where no protective device was done. I'm not asking you to resolve any factual situations. All I'm suggesting to you is that even if you disregard everything the plaintiff says, under the defendant's version of the accident, plaintiff should win on 240.
Counsel, I just want to make sure I'm understanding your argument. Your argument is that even if this weighed 100 pounds and was 3 feet by 7 feet, and if the elevation to which it had to be raised was only 3.5 feet, that would still be a 241 case and that there still should have been other safety equipment?
Yes, because
Is that based just on the fact that there was an accident?
No, it's not based on the fact it was an accident. It's based on the configuration of the door, its weight, the plaintiff's testimony, the fact that 2 people were lifting it. No one disputes that there were 2 people lifting it. So
Was there any expert testimony about what was needed to prevent this?
there was no expert testimony because I don't think expert testimony was required in a situation like this. And as you know from the O'Brien case, it's always dangerous to put in an expert testimony when you're moving for summary judgment because the defendant can put in countervailing expert testimony. Sure.
How do you address the fact that the foreman, I believe, had indicated that the door could be easily lifted by 2 workers and neither the forklift nor a hoist was required for disposal? And there was also some other information that I believe that Franco was not even present at the work site and didn't give the directions to dispose of the doors in the manner that plaintiff had described. Can you address that?
So, Justice Kennedy, with respect to the Franco direction, my position is it's irrelevant, because it doesn't matter who gave the direction. It would be relevant if Franco had said something that plaintiff disregarded, and nobody, even Massimo, doesn't say that the plaintiff was disregarding a specific command under Gallagher and its progeny. With respect to the 3.5 foot argument, I would ask the court to take a look at a case called Lee, it's cited in our brief, against Sloan Kettering. It's at 176 AD3D 561, First Department, 2019. Admittedly, that was a 300-pound coil, but it was a coil that was on dollies that was lowered on a truck on the liftgate on the ground. And when the dolly moved, the coil fell and hit the plaintiff.
You said it's how many pounds?
300. It's
So
definitely.
really no question, really, when we see things that are 300 pounds that fall. But can you just tell me what cases you're relying on for the proposition that you suggested here, where we have to do it based on the configuration, et cetera, et cetera?
Oh, sure. I'll give you, there are 3. I knocked it down to 3. And I'll get to it in my reply. I'm sorry. The first is Cuevas, C-U-E-V-A-S against Baruti, B-A-R-U-T-I. I have the site right here. I'm sorry. It's 164 AD3D 447. And I'd ask you to look at the Gutierrez against 610 Lexington property case. It's 179 AD3D 513. And the last one's Lee against Sloan Kettering. It's at 176 AD3D 561, all First Department cases.
Wait, the Sloan Kettering is the one with the 300-pound object?
It's the one with the 300-pound object that's being loaded on the back
I
of
don't
the
really
truck
see
on
how
the
that
ground.
one's relevant to this. And anyway, thank you. You've gone.
Thank you.
Given you much more time.
Good afternoon, Your Honors. May it please the court. Your Honors, in this case, the plaintiff is standing on the ground. He's with 2 other co-workers, 1 other co-worker assisting him, helping him.
He's got a door. It's on this, whatever kind of dolly this is, that requires somebody to push it because it's cumbersome or kind of wieldy enough so that these 2 workers, I guess, can't do that alone, right? So there's a 3rd person who's pushing it, right, toward the truck?
There's a 3rd person holding the dolly, Your Honors. Yes.
Right, holding the dolly, because this 100-pound thing that doesn't need a hoist is going to make the dolly move. And these two people pick it up. He says he has to lift it 7 feet, I think, or something like that. Isn't that right?
That's plaintiff's claim, Your Honor.
Plaintiff says he has to lift it that high, and they're both holding it up. I don't think there's any contradiction to that, is there? That it wasn't
Yes,
lifted
Your
that
Honor.
high?
The height, as Massimo puts forth in his affidavit, is that the opening to which he has to lift it to is 3 feet.
3 feet is the height of the truck, I thought they said.
3 feet is the height to the opening, I thought, Your Honor. That's how I read it.
Okay, I'll have to look. And he lifts this, and then it falls on his finger. Is the fact that it falls on his finger and severs his finger, this glass with metal surrounding it, is that not enough to suggest that a hoist was required here, where they had to lift a door that was heavy enough that the dolly needed to be secured by another person, and heavy enough that when one of the two faltered, it severed his finger? Is that not enough?
Your Honor, I don't believe that that's necessarily enough. In this case, there's 2 persons lifting it, and if you, in one of plaintiff's statements that he made to his treating physician is that the coworker let go of the door, and that's what caused this incident. So it's not that the door...
Because he wanted to, or because the weight was, or the cumbersomeness of it was too difficult for him to hold it?
It's unclear, Your Honor.
You think he wanted to? Is that what you're saying?
He may have lost his grip because it was slippery. He may have lost his...
Well, if
we
it
don't
was,
know.
if it was slippery, would that not have been a condition of the door?
No, Your Honor. I don't believe so. If it was slippery or whatever we're surmising, Your Honor, actually, that's the whole problem, is that we're surmising on that.
The whole problem is that the door fell from an elevated position onto this person's hand, and we're quibbling over the weight. That's what the whole problem is, whether 100 pounds is something that 2 people should be able to carry, even though a third person is needed for a dolly. Whether 100 pounds is too light, even though it can sever somebody's finger. That's what we're quibbling about.
Right, Your Honor, and the fact that we're quibbling over it is just proof positive of the fact that it's a question of fact.
But wait a minute, if it's slippery and you think that could be the reason why it fell out of the worker's hand, isn't the slipperiness something that would also require some safety device so that it wouldn't slip out of someone's hand?
Your Honor, that was just something I was throwing out. There's no proof that it was slippery. There was nothing in the record indicating...
Well, then don't throw facts out that aren't part of the record.
Yes, Your Honor.
If that's the best you can do, is throw facts out, maybe there's an issue here. If the facts you have don't bear out that there shouldn't have been, that the safety devices, whatever they were, faltered, and that there should have been a hoist here.
Well, my point, Your Honor, is the fact that the facts don't necessarily bear out, and that's why it was proper for the lower court.
But it seems to me the only real issue here is whether the door was 120 pounds or 300 pounds. Regardless of how much it weighed, its weight and the force of gravity upon falling, for whatever reason, the guy helping him got a cramp, who knows why he let go, okay? But it severed his finger, it crushed his hand.
Yes, Your Honor, there is no disputing the fact that it did sever his finger.
But my point is, the only issue in dispute is the weight of the door.
The only issue in dispute is the weight of the door, correct.
And on the basis, just on that basis, that's enough to send this to a jury.
Your Honor, we believe that that is enough to send this to a jury because it's the question as to whether or not this falls into the ordinary course of dangers or into the extraordinary protections under the Labor Law 240.
So the ordinary protections of labor law subject employees to the risk of having their fingers cut off?
No, Your Honor, they do not. However, there's other sections of the labor law that would protect the plaintiff, such as the 241 and 200 claims. But what I'm saying is that this wasn't an elevated or a height-related risk that required this isn't a height-related type risk that 240 envisioned.
Thank you.
Thank you.
Good afternoon. Patrick Lawless for the third-party defendant respondent. The lower court correctly found that there were numerous issues of fact in this case as to how the accident happened and whether safety devices were required. There's no evidence in this record as to what safety devices should have been supplied. The affidavit of Mr. D'Amico clearly establishes that or at the very least raises an issue of fact that this was a 100-pound,
But plaintiff's counsel says that whether it was 100 pounds or 300 pounds doesn't matter because the configuration of it was such that he still needed other safety devices, whether it was a sling or something else, or to lift it safely from the level where it was to into the truck. So, I mean, assuming for the sake of argument that Mr. Isaac's position is that 300 or 100 pounds doesn't matter, it's still dangerous if it's 100 pounds and only 3 feet by 7 feet.
But there's no evidence in the record that the configuration caused this accident. Mr. D'Amico states in his affidavit that they should have, he gives the dimensions of the door and said that it could have been easily handled by 2 workers into the garbage truck.
But it wasn't.
It was a 100, it was 100 to 120 pounds. Okay, we've established that's where we differ, that or the 300 pounds. But it is 7 to 8 feet tall. That's unusually tall for the average person. And I don't know that it said what height these people were, but they're trying to lift this 7 to 8 foot tall door. The 100 and 120 pounds becomes more complicated when you're talking about that, doesn't it? And it's 36 inches wide.
Again, there's nothing in the record, just given the dimensions, whether it could be lifted or not, by these 2 workers, that there was difficulty. That is something that, given the dimensions, that the plaintiff's counsel is saying now, but there's nothing in this record that states that they would have had any difficulty doing that, just lifting this 3 feet off the ground.
Well, let me ask you something about this. It says that the lip of the garbage truck was 3 to 3.5 feet off the ground, which I'm not quite comprehending because most garbage trucks, just to get over the wheel well, is 3 to 3.5 feet. So I'm not clear on whether or not, usually there's a back that goes up and down. Are there pictures in the record? I didn't see any of the truck. So are there? Because 3 to 3.5 feet, I don't see how the back of the truck, everybody's talking about the back of the truck. He says the lip of the truck, which doesn't necessarily indicate that that's where that there's not another 3 feet that would be consistent with what the plaintiff says, that it's 7 feet that he's got to lift it if the back was up and there was something he was trying to get it over.
All I'm saying is that
Is there anything in the record with regard to that?
Mr. D'Amico's statement is that the back of the lip of the truck was 3 or 3.5 feet, and and no device would have been needed for these workers to lift this door.
Except the lip of the truck is not on the floor, right? So a truck has wheels, and then it has a chassis, and then there's the body of a vehicle on top of it, right? Okay, so wheels on a garbage truck have got to be at least 2 feet tall, no?
That's
Is that a yes?
This is what's.
I understand that, but I am testing the evidence, right? So your witness says that the lip is 3.5 feet high. 3.5 feet high from where? From the floor?
Yes.
Where is that in the record?
It's in his affidavit.
That he says it's 3.5.
I believe he states in his.
Wait, the lip is 3.5. I'm trying to understand what kind of truck this is. Is this a flatbed truck? Counsel.
It's not clear
it's
from
your client.
It's not clear from the record, but what he testified to was that the lip of the truck was 3 to 3.5 feet from the ground. That's what's in the record. All the other points.
Well, the only way that's possible is if it's a flatbed truck with some kind of door that flips down.
That's not in the record. All
It's
this.
not. All it says is conveniently that the lip of the garbage truck was 3 to 3.5 feet off the ground, which I don't quite understand without further what the lip of the garbage truck is, because that to me is just the flatbed part of it and not the door that keeps all that garbage that they've been carting in there all night in the truck and not on the ground as they drive away. Anyway.
I think these would all be questions for the jury.
Yes.
But also, the evidence is that these are demolition workers, and they handle debris all the time.
You
and
know,
there's
so
no
does
evidence
every other worker who's before us on whatever case. They've all done the work before, and, you know, that's why they have these cases, right?
Other than the dimensions, there's no evidence in this record, other than Mr. D'Amico's testimony that these workers should have been able to handle the doors without any problem. There's no testimony or evidence in the record that these doors were unwieldy or difficult to handle.
Thank you.
Thank you.
Is there anything in the record about this truck?
I'm sorry, Justice Manzanet. No, the record, there's no pictures. Justice Renwick pointed out there's no pictures. I thought from reading the plaintiff's testimony, the plaintiff also said there was an opening. I thought they were talking about, I think the truck is higher and there was an opening to put the garbage in. You know how the trucks kind of flatten out? That's what I thought he said, but it's not, it's certainly not clear. The plaintiff's testimony was a little disjointed because he didn't speak English and he was using an interpreter, and there were a lot of times he didn't answer questions. But
Counsel, I have to, if you've done with Justice Manzanet, I have to ask you, isn't this conversation, these questions that we've been doing here, going back and forth, doesn't it underscore the fact that these are questions of fact that should go before a jury?
My answer would be no, obviously.
Of course it would be.
And let me tell you why. Let me give you a visual that I actually thought of when I was being questioned by the panel. Perhaps if I was questioned by the panel before I wrote the brief, I would have written a better brief. But I had to my house delivered paper the other day in a box. It's 50 pounds. I tell you, I can lift 50 pounds without any problem at all. It was in a box. When I picked it up and I had to walk it down the stairs, I was making sure I didn't fall. There's a huge difference between looking at the weight of an object in isolation and looking at the weight of an object in terms of its configuration. 50 pounds, to me, was like 200 pounds. Even though I can easily lift a 50-pound dumbbell, lift them up both sides. I had problems lifting that off the ground because it was wide and because I had to hold it on the side. That's the same thing here. So my argument is, I don't really care what these other facts are, because I don't believe they're material. And I would point out one other thing, because I see that you're struggling with the same issues I was, which is visualizing what happened. There is one fact I wanted to tell you. 114 of the record, the door didn't break at all. The door was intact. So it's not like the glass came and severed what happened. And the other thing is that in a case such as this, where you have to lift this type of object, you have to remember that the plaintiff testified that the railings that were on the dolly that were being used to push it, they decided to lift this door by putting, because it was vertical, right? We all know it was vertical. They pushed it on top of the railings. So whether the back of the truck was 3 feet, 7 feet, or 6 feet, doesn't matter. That's what they used because it was vertical. They were pushing it over the railings. So it had to be at least 7 feet high because that's what the railings were. So to me, there are multiple discrepancies, but I don't believe that they're material under your decisional law, and we would ask that you grant us summary judgment. Thank you.
People versus Boris Brown.
Thank you.
Good afternoon.
Good afternoon.
Please the court, I am Matthew Brock of Davis Polk and Wardwell on behalf of appellant Boris Brown. Mr. Brown is entitled to a new trial because his attorney, Mr. Chabrow, was paid for by a gang leader, Mr. Salam, who Mr. Chabro also represented in another action, and who is a suspect in this shooting, including because, as the people revealed in the
What
Brady...
evidence is there that he was actually a suspect in this shooting? I mean, it seems to me that what happened very quickly is that the people decided he was not a real suspect.
Well, Mr.
I mean, I agree with you. If he were a suspect, it would be a very different situation. But as far as I can tell from the record, I don't see that he is. What evidence is there that he was?
The evidence against Mr. Salam was never disproven. The people in a Brady disclosure revealed that a witness had identified Mr. Salam as the shooter. Mr. Salam was present at the
But
scene.
that was hearsay or double hearsay, wasn't it?
Certainly, that statement was hearsay. There was evidence in the record that Mr. Salam was the shooter, including that there was a 911 call in which he was named as the shooter.
And that's also hearsay and anonymous as well, wasn't it?
Yes, we're not disputing that Mr. Chabro, who was a conflicted attorney, did not develop admissible evidence to implicate Mr. Salam, who was Mr. Chabro's client and who was paying Mr. Chabro.
But I'm asking whether there's any evidence that the people considered him a real suspect. And so far, what you've told me are two pieces of hearsay evidence, which I wouldn't have thought would be sufficient to make him a suspect for the people.
He absolutely was a suspect. The police had issued an I-card from him originally, and again, the people...
But an I-card can be issued for a witness, right?
He was considered a suspect, and then at the time Mr. Brown confessed, the people turned their focus to Mr. Brown. However, Mr. Salam's involvement was never disproven, and as Mr. Brown's attorney, Mr. Chabro had an obligation to try to defend him as best he could, which can include developing evidence.
But he said that he had considered those things and that they would have been worse, not better, that he thought he had a better chance following up on the evidence in the way he did.
He also said if the evidence supported that this gentleman was the shooter, that he would have pursued that.
The fact that Mr. Chabro testified that he was considering whether to accuse his current client, who is also paying him, of murder, is showing us that there was a conflict here. He owed competing loyalties to these two men. As he recognized, he could defend Mr. Brown by implicating Mr. Salam.
But when you say that Mr. Salam was paying him, isn't that conflating the facts a little bit? Because as I read the record, Mr. Salam was delivering the money to the lawyer, but that it was essentially crowdsourced.
Well, there's no dispute that even if it was crowdsourced, Mr. Salam was part of that crowd. And let me just read to you his testimony on page 47 of the hearing transcript. He testifies with respect to Mr. Salam. He was handing over the money. It was my understanding that certainly some of it was coming from him. So Mr. Chabro understood that Mr. Salam was providing him with at least some of that money from his personal funds. And it's that understanding that made Mr. Chabro financially beholden to Mr. Salam. He believed that he was being paid by Mr. Salam and did not want to bite the hand that fed him by accusing him of murder.
Counsel, what proof do you have that Salam used his particular funds? Because just like my colleague said, this was, crowdfunding. And certainly when Salam was incarcerated, it was the mother who was then bringing the funds.
Well, so there are multiple recorded phone calls in which Mr. Salam discusses how he's the one putting together the funds for Mr. Chabro. But again, the clearest evidence is
But
Mr.
putting
Chabro's...
together doesn't mean going only into his own pocket.
Of course, Your Honor. And Mr. Chabro's, the clearest evidence is Mr. Chabro's testimony, where he said that he understood that at least some of that money was coming from Mr. Salam. And it's that understanding that is key here. Mr. Chabro believed that the money was coming from Mr. Salam. So he may have been wrong, but so long as he believed that, he felt beholden to Mr. Salam.
Well, then how would you address the fact that it was the defendant that said to the attorney, my people would put, together the cash and deliver it to him. And every time Salam came to the office, he had other people with him.
This isn't, whether or not this was crowdfunded is of no moment. Mr. Chabro...
Oh, no?
Well, Mr. Chabro understood that some of that money was coming from Salam, and our position is not that every cent has to be tied to Salam. Mr. Salam, so long as he was providing a significant portion, which Mr. Chabro understood...
What's the evidence of a significant portion?
What's the evidence there?
Again, Mr. Chabro understood, and even if he was wrong, his understanding that Mr. Salam was providing some of that money out of his own pocket is grounds for a conflict. All right, thank you.
Good afternoon, Your Honors. Sylvia Wertheimer for Respondent.
Counsel, defense counsel said that the fact that the lawyer was getting paid by both individuals and had to think through competing issues with regard to both, whether to put the defendant or the other person on the stand, shows the conflict right there. Why isn't that correct?
It's not correct, number one, because as Judge said before, first of all, there was no evidence here that the burden of proof at the hearing was on the defendant. Defendant did not prove that Salam paid or hired Chabreau to represent defendant. The fact that
Right, you're right. He didn't, we're not saying, or the evidence doesn't show from what we see that he was the only person, that Salam was the only person, but he was one of the people. That was pretty clear, and he was the person coming with it. So he's still a main player in the payment of money. He's still giving something from him to this lawyer, and he's a client of the lawyer, or has been. So, and the lawyer is trying to consider whether the defendant or Salam is the shooter, or going through that scenario. Isn't that a conflict in and of itself?
Well, I would say no, because first of all, the defendant was undeniably there. Defendant never told Chabreau that Salam was a shooter. There was absolutely no admissible evidence that Salam was a shooter. It's also very significant that this whole argument that they should have pointed to Salam as a shooter is based on the same hearsay evidence and speculative inferences from evidence that the people investigated and concluded did not warrant bringing charges against Salam. So in that situation, we're here at a 440-10 hearing. You can't just there have been years now since Mr. Chabreau was out of the picture. There's not one iota of evidence, admissible evidence, that Salam was the actual shooter. So as to that, certainly, if Chabreau might have had such evidence, that would have put a conflict. But there wasn't any such evidence. And we know that from the hearing.
The fact that there might have been a suggestion of such evidence is not enough for there to be a conflict where all of the other factors are there.
Right. A suggestion would have been based on the same evidence that the people already had determined was hearsay and speculative inferences that didn't support. So Judge Klott was correct that here, in this case, they just did not have clearly antagonistic interests. In addition, in terms of the payment, I think it's very significant that the record shows very clearly the hearing that defendant was the driving force behind retaining Chabreau to represent him. I mean, this whole idea, and defendant now says, oh, that's irrelevant. But it's not, because the whole construct the defendant presented was, oh, Salam hired Chabreau to make him like his patsy. But the fact of it is that's entirely disproved by the evidence of the hearing. In particular, the phone calls the defendant introduced at the hearing. What's startling from those is how defendant is pushing for Chabreau to represent him. And as the court said, the evidence really just showed that Salam was acting as a facilitator for defendant who was in jail and couldn't bring the money himself. Also would say that there's no indication as to what amount, whether Salam provided significant sums or not. And I think the key testimony from Chabreau is that he believed that it was being crowdfunded by a whole group of people. That means that he didn't have to worry about placating Salam because somebody else would have stepped in. And all the evidence was consistent with that. The phone call that Judge Kennedy cited before, where you have defendant saying, my people are right now in the process of putting together the money. They can have 4,000 now. They're trying to come up with another thing. I mean, the defendant is driving all this. So there.
I have another question.
Yes.
With the phone call, right? Because I was under the impression that the defendant, interviewed a number of attorneys and thought that Chabra was the best. And then he wanted to retain him. And there was, I think, another phone call with the mother and the defendant. They talked about the payment schedule, what the retainer would be, the fee, and then Salam said he was calling on behalf of Boris Brown.
That's absolutely correct.
I have another question. Now, because counsel said that there was no investigation, but I was under the impression that the police had investigated, said they couldn't find any, credible information about who was the shooter because the person who allegedly gave that statement wasn't even present, right? You had the police and even defense.
There was ample investigation. The people testified, the prosecutor testified. This was a horrible case. This was a depraved murder of a 17-year-old girl who was just sitting in the courtyard on a Saturday night trying to have a nice time. The people wanted to hold responsible everybody who was criminally responsible. The people investigated all of these rumors. The people investigated the phone call, everything, and they determined there was no evidence. Now, here we are after a 440-10 hearing. At that 440-10 hearing, defendant did not bring forth one, in all these years, additional admissible piece of evidence to suggest that Salam was a shooter. Defendant who was there has never said Salam was the shooter. Conflicts certainly are very important, but it's not supposed to be a game to allow somebody to escape a conviction when here there's just the evidence of the hearing totally belied the construct that led the Court of Appeals to order a hearing, which was that Chabreau, that Salam made defendant his patsy by hiring. So we said the only possible conflict that could have been here was a potential conflict. Mr. Chabreau said that it did not operate on his defense. The court credited his testimony. In sum, the defendant was given an opportunity to prove the allegations behind his conflicts claim. He utterly failed to prove them, and this court should affirm the order denying the motion to set aside the conviction for this depraved indifference murder of an innocent 17-year-old girl. Thank you.
Thank you. So, counsel, why isn't this a potential conflict, not an actual conflict that would act on the counsel here?
Even if this is a potential conflict, Your Honor, it still entitles Mr. Brown to a new trial. The clearest evidence that this conflict operated on the defense is when Mr. Chabreau attempted to implicate Mr. Salam and was told by the court, you can't do that. That would be a major conflict. And thereafter, Mr. Chabreau dropped this defense. So this conflict actively prevented him from bringing this defense. It also operated on the defense when, as we discussed earlier, Mr. Chabreau at the outset thought, do I implicate this one client in order to protect the other? That is another example of this operating on the defense. Of course, we maintain that this is an actual conflict, in which case Mr. Chabreau's conduct at the trial does not matter. And let me emphasize that it's undisputed.
Does it matter then, and sorry to stop your flow, but does it matter that all of these things were hearsay and really wouldn't have amounted to anything that could have been brought at trial?
Once again, we do not
dispute. Doesn't that make it potential?
Once again, we do not dispute that Mr. Chabreau did not develop evidence against Mr. Salam, who was his client and who was paying him. We believe that fact entitles Mr. Brown to a new trial where he's represented by counsel who's free of conflict, who is free to develop that evidence and, if it proves fruitful, bring that defense. Mr. Chabrow could not bring that defense because it was a major conflict, and he
Or
did not.
perhaps because there were no facts to support it. You make this argument as though it is a fait accompli, that there was evidence that Salam was the shooter. And there is nothing in the record that supports that. Nothing at all. And we know how this started, right? I mean, we haven't talked about it, but we know how this started.
Your Honor, the fact that there isn't evidence is why we need a new trial. Mr. Chabrow did not develop admissible evidence against his own client.
Because there's no evidence, we need to do a new trial in the hopes that perhaps something might fall out of the sky.
Or not, Mr. Brown is entitled to an independent attorney who is free of conflict, who can look for evidence against Mr. Salam. Mr. Brown was denied that right and is thus entitled to a new trial.
Thank you.
Thank you, Your Honors.
Are you here pro bono?
Yes, ma'am.
Yes, thank you very much for your service and appreciate your firm. Who are you with?
Davis Polk and Wardwell.
Yes, and we thank the firm for allowing you to appear pro bono. Thank you
Your
very
Honors.
much. Thank you both. Burlington Insurance versus Cookman Best Insurance.
May it please the Court, Tricia Starkey for Defendant Appellant New York Supermarket East Broadway, Inc. This is a priority of coverage action. It is a dispute between the insurance carriers stemming out of a personal injury action.
Counsel, where is the evidence that Burlington and Aglick gave up their right to litigate the subrogation issues here when the stipulation wasn't signed and it doesn't state that there's a third-party action and their conduct was not consistent with a waiver of those issues?
To address the third-party action being omitted from the stipulation, that was not intentional. That was, if you look at
Sure it was. It was included and scratched out. So it was specifically removed from the settlement order.
the stipulation that was filed with the court in 2017 bears the original caption for the matter, which is incorrect. The original caption only names New York Supermarket, which is a different entity than New York Supermarket East Broadway, and still names the city, which pursuant to the summary judgment order and the personal injury action, the caption was to be amended.
So what about this?
But when they exchanged drafts, it did include the draft for the later action, and that was later crossed out, wasn't it?
It was not crossed out, Your Honor.
It was, in some of the drafts it was there, and then in the final draft that was signed, it was not there, correct?
Correct. The original
So
draft
it wasn't unintentional. There had been it had been included, and then in the course of the negotiations, it got excluded, right?
The initial draft that included the third-party action was drafted by plaintiff's counsel's office in that action, the plaintiff's sues counsel. It was then a separate firm that drafted the other stipulation that was used, and that stipulation was the original one that contained errors. It didn't, the only, and Burlington and AGLIC in their papers concede that the only substantial revision that was made to the stipulation that was filed was the removal of the word without cost, because they intended to pursue the subrogation claims of the priority of coverage.
But another substantive change was the removal of the second caption.
And the other substantive change was they kept the city as a party in there. They did not include New York Supermarket East Broadway, Inc. in the caption, and they mistakenly moved, the word claim does not appear in the stipulation that was filed. It is sloppy. It's a very sloppy
So why don't we get to some of the other
things? It was
things?
not intentional for the third-party action to be dismissed. And
Okay, what about the fact that they didn't sign it? Is the party able to sign for the insurers to release them from their right to subrogate? The
No, the
subrogation
Burlington and
action?
AGLIC are not parties in the personal injury action. Only their insured Winking has the ability to sign.
Exactly, but Winking doesn't have the ability to limit or change the subrogation issues that the insurance companies have.
Well, actually, Your Honor, New York law has found that the insurer subrogation rights against a party, a third party, that has been released or settled from liability, that subrogation right may be destroyed. And if I can bring your attention to the 2017 case, Millennial Holdings versus Glidden, 14683D539, where Justices Renwick and Manzanet Daniels were in that decision, and that decision later was affirmed in 2019, where Justice Gessmer was in that decision.
But that decision didn't have all of the facts that this one has, where where the Winking's trial attorney also submitted a motion in limine to exclude from the trial the contractual indemnification issues, where in his affirmation he indicated that he had informed NYSEB's insurers on the day of the settlement and earlier that they weren't going to be a part of it. We already discussed the evidence about the prior drafts. I mean, there are other aspects here. There are other facts here.
If I may, New York Supermarket, East Broadway, was Plaintiff's Zoo's employer. They have no direct liability to the Plaintiff's Zoo in that case. Therefore, the settlement that they contributed to was pursuant to their contractual indemnification obligations owed to Winking. There's no other logical reason why New York Supermarket, East Broadway, Inc. would have paid voluntarily when, other than the fact that they were paying pursuant to their contractual indemnification obligations owed to Winking.
Well, we know that even though we know that already, that still doesn't establish that Winking could waive Burlington's and American AGLIC's right to subrogate.
The difference between the lower court focused, and same with respondents, focus on the case FASO, and those cases are in the context of health insurance, where there's a statutory obligation, and those health insurers are not the insurers that are appointing the defense counsel that are involved in the lawsuit. Here, Burlington appointed Winking's counsel. Burlington is the one that is directing and controlling. They are involved with the negotiations, the settlements. They know that they're agreeing when they stipulate to discontinue the personal injury action, that those same claims for contribution.
Counsel, this is precisely why they took the caption out. And there's no language in here that says the indemnification action is hereby released also. There's no language.
So then procedurally, if that third-party action was not discontinued, then it is still alive. No party has proceeded under that third-party action number in 5 years. In fact, Winking never filed any records with the court using the third-party action number. The lower court tracked both the main party and the third party under the same index number, and it was marked disposed. If that stipulation of discontinuance did not discontinue, essentially the lower court held that the main party action was discontinued with prejudice, but the third party action was discontinued without prejudice. If that action is still alive and was not discontinued, then the claims brought in the DJ action are prior action pending and should be dismissed under 3211A4.
And what about the motion in limine? There was never a challenge to the motion in limine that by NYSEB. The motion in limine was to exclude from the trial, from anything, the contractual indemnification issue.
The motion in limines were never actually argued before the court. This did not go to trial. It was settled before trial.
But there was never any challenge to it. There was never any question about it.
Our firm was not defense counsel for NYSEB at that time.
And that was after NYSEB's insurers had made their settlement payoff.
They made that payoff pursuant to their contractual indemnification obligations to Winking. They had no obligation,
Where do they say that?
just logically.
No, forget logically. Where do they say that? We're dealing with a document that settles an action. We are bound by the four corners of that settlement. You are asking us to assume, of course they meant that. What else could they mean? I don't know. They have to put it in their agreement so that we know exactly what the parties intend. And what we see is that there was no intention to give up the subrogation
If I may
rights.
respond then, for that argument to take it literally, the word claims is never used in that stipulation. So even plaintiff's claims would not be discontinued. Because there's no, they don't, it says action. There are, and arguably, when New York Supermarket, East Broadway, was added as a direct defendant, Winking asserted cross claims, and pursuant to CPLR 1009, the third-party action converted to cross claims. So that main party action, those Winking's claims for contribution and contractual indemnification were cross claims and were discontinued in that main party action as well.
Thank you.
Good afternoon, Your Honors. James M. Adrian Associates for the Burlington Insurance Company. I believe the questioning and the dialogue has covered a lot of what I was about to say, but one thing that came out during the colloquy was a concession that, the stipulation was sloppy. We've cited case law, and Judge Kelly on page 9 set forth a standard in his May 3rd, 2021 decision, basically saying, in a motion to dismiss context, which I think we need to focus on, that the pleadings are liberally construed, all allegations taken as true, and plaintiff is also afforded all possible inferences. And, most importantly, that the documentary evidence must utterly refute the factual allegations and establish a defense as a matter of law, and that's Judge Kelly's decision at 9. Sloppy stipulations and utterly refute are kind of a non sequitur, and they're inconsistent statements. The bottom line is what New York Supermarket wants to do is void the underlying indemnification decision, which was not opposed, was not appealed, and they want to kind of rewrite plaintiff's stipulation of discontinuance and the release. I guess the example that was just provided was, if you look at the stipulation and construe it that way, then the plaintiff's claims would still be pending. Well, it was a separate release, and that release only flowed from the plaintiff to the defendants. The stipulation did not list counterclaims, did not list cross claims, did not list the third-party index, did not list the third-party caption. The bottom line here is, from a common sense standpoint, and insurance companies do this all the time, if there's a separate DJ, which there was, which put New York Supermarket on notice that, hey, by the way, we're moving as a subrogation, in a subrogation context against you because we're going to pay money to settle this case. If they wanted that case dismissed with the entire underlying action in a global sense, there would have been a settlement release, and there would be a separate stipulation in the declaratory judgment action, and probably the third-party caption.
There would have been all the bells and whistles, then,
Yes,
you're
I mean,
saying, to
this
make
is just-
sure it was gone.
This is a thinly veiled attempt to try to avoid a subrogation claim, and I give it to counsel, they've tried everything in this case. They've argued collateral estoppel, they've argued res judicata, they've also, I guess, ignored. They've said that they paid on behalf of Winking when the Burlington Insurance Company asked a number of times for them to do so, and they didn't do so, but then they added to the record, which they're not supposed to do, on a motion to dismiss, by saying that they actually made their payment on behalf of Winking, which absolutely never happened. And one other point, and I know my time is getting short, is the fact that the Burlington Insurance Company paid this money before the stipulation was signed. The subrogation rights vest at that point in time. I thought Judge Kelly's well-reasoned decision, I mean, it was 16, 17 pages long, cited a number of cases that said, once you make that payment, nothing can be done by the insured or the injured party or other parties to, to limit or qualify the subrogation rights of the insurance carrier. And frankly, while 5% of these cases go to trial and the dockets are pretty packed in most states and certainly in this jurisdiction, if you can't pay money and have your subrogation rights, if those rights can actually be limited and taken away a month later because someone signed a document that you weren't a party to, the courts would be, nothing would settle, and the courts would be even more overwhelmed. Thank you.
Thank you.
Thank you, Your Honors. Patrick Coughlin on behalf of the respondent, American Guarantee. I join with the arguments made by co-counsel for Burlington and rely primarily on our brief. There's a lot that's packed in there, but there are a couple of points that I just want to stress for the panel. I think Your Honor's questions to New York Supermarkets Council hit the nail on the head. Here, there can be no dispute that my client, American Guarantee, paid to settle the underlying action on behalf of Winking. At that point, upon payment, its subrogation rights attached. There can also be no dispute that New York Supermarket and Winking were aware of those subrogation rights and the fact that they had attached. The general release that was executed by the plaintiff, which is in the record, makes express reference to American Guarantee's payment. They also, and this really, the entire appeal hinges on this, I think, they can't point to any writing or any other evidence beyond their so-called, and I would add self-serving, common sense understanding that American Guarantee had any intent to release its subrogation rights. That should end this appeal. The Court of Appeals in Faso versus Dorr from 2009 could not have been more clear that under these circumstances, an insured such as Winking cannot terminate attached subrogation rights. They can't really challenge this. What they try to do is they try to box Faso in and say that's a health insurance case. The problem with that is if you look at that decision closely, the Court of Appeals cited the wealth of authority in New York and elsewhere for the proposition that once a subrogated insurer has to consent in order for a release of its rights to be effective. And I would note that the foundational case here in New York, the Hooker Electrochemicals case from 1925, it's old, but it's not stale. It's still getting cited. That was a classic third-party general liability case where an insurer settled on behalf of a defendant and then sought subrogation from a co-defendant who manufactured a defective component of a product that exploded and caused injuries. And there the Court of Appeals said that under those circumstances, quote, the subrogee acquires rights which as between it and the insured are beyond the power of cancellation and destruction by the latter, and under our practice, I would stress this, is entitled to enforce these rights by an action in its own name and without joining the insured as a party. And this goes to the heart of this procedural roundabout that New York Supermarket's trying to create confusion and say, well, if the insurers can proceed here, then what happens to the underlying case? It's totally irrelevant. Upon payment by American Guarantee, those rights belonged to American Guarantee. And the Court of Appeals says that we can pursue that in our own action. We don't have to intervene or chase it through the underlying action. So what we've done here along with Burlington is perfectly consistent. I think the Court's questions about the substance of the stipulation that was entered into in this case are on point. We cite a counter stipulation in the Navigator's case that was entered that made express reference to all cross-claims, counterclaims, and third-party actions. We don't have that here. And on a motion to dismiss under CPLR 3211A5, while New York Supermarket can introduce the document to further its res judicata or collateral estoppel argument, they cannot try to impute meaning that is not reflected in the express terms of the stipulation. So for all of these reasons, we think that the trial court, in a very detailed, thorough analysis, properly rejected their arguments. The trial court properly held that collateral estoppel, in fact, bars New York Supermarket from relitigating its contractual indemnity, and we would ask the court to affirm. Thank you.
Thank you.
Our first point we'd like to make in reply is New York Supermarket East Broadway does not challenge the personal injury summary judgment and is not attempting to relitigate its contractual indemnity obligations. In fact, New York Supermarket Inc., their insurance carriers paid pursuant to those contractual indemnification obligations owed to Winking. Winking brought contractual indemnification claims and contribution against New York Supermarket East Broadway. As counsel said, their AGLIC and Burlington, as insurers, can only step into the shoes of their insured Winking, and they are therefore limited to those rights. Yes, we concede that their rights to subrogation attached when they issued payment, but subsequently, that settlement discontinuance of stipulation of discontinuance with prejudice pursuant to the settlement agreement that was filed subsequently, therefore terminated not only Winking's rights against New York Supermarket East Broadway, but also AGLIC and Burlington's subrogation rights for those same exact claims, contribution and contractual indemnification against New York Supermarket.
How do you address counsel's argument that if an insurance company's subrogation rights could be waived by its insured without the insurance company signing on to that, that would essentially end all settlements because no an insurance company would never settle again if their rights of subrogation could be waived by their insured?
To that same point, parties enter into a stipulation of discontinuance with prejudice for the sole purpose of protecting themselves from further liability of exposure of those same claims. It would set a dangerous precedent to allow them.
But the insurance company didn't enter into that stipulation.
The insurance company who appointed defense counsel to handle and defend Winking's claim, which to
settle their claim, not with regard to subrogation issues.
Right, so their claims, their subrogation claims and priority of coverage, those claims and those rights still exist.
To settle on the personal injury action where the man fell down the chute, fell down the elevator shaft, not to determine the subrogation rights that were vested in the insured.
The subrogation rights were vested, but once that settlement agreement was made and the stipulation of discontinuance was filed, that agreement, as per this court's holding in
not
Millennium
without
Holding,
the magic language, counsel. All your people had to do was add, this resolves the cross claims, counterclaims, all claims.
And
it did not say that.
And it also did not carve out or expressly reserve the third-party action for them to continue to pursue.
Well, that's against you, because it's just not there. We can't read into what is not there. We have two parties here, neither of whom are insurers, who signed the document. That's not going to bind the insurers and prevent them from pursuing the subrogation rights. Thank you both. Thank you all. Lively versus Wafer Investment.
Thank you, Your Honors. Good afternoon, and may it please the Court. Christopher Zona from Brewer Attorneys and Counselors on behalf of Plaintiff Appellant Francis Lively. Here, with all respect to the Supreme Court, it wholly failed to follow this Court's very clear and unequivocal precedent from Williams, and it failed to—
Counsel, I'm sorry, but just to get right to the point here, your client says that he was fired because of sexual harassment. but he says that, he says that he was fired because of racial discrimination and that age discrimination, and that sexual harassment was a ruse. But this sexual harassment was something where he had already settled a claim, and it was quite extensive in terms of the statements that he made. And during the period of these age discrimination comments, the period that followed that, he was promoted and he was touted for his excellent work. And he wasn't fired until 6 months after those statements. So how is the sexual harassment a mere ruse here?
Certainly, Your Honor, and I think that goes to a couple different things. So first, the sexual harassment should only be considered in the McDonnell-Douglas burden-shifting analysis, which the United States Supreme Court in Swierkiewicz has held is inapplicable at the notice pleading stage. We are not in a plausibility pleading state. That's what the SDNY dealt with. That's what the Second Circuit dealt with. The portions that are cited in the Supreme Court's determination on this case from the SDNY case deal with plausibility pleading. All Mr. Lively has to do here is notice plead sufficient facts to plead his claim.
Okay, that's fair enough. But where's the causal connection then between the age discrimination and the firing, given what I said, the 6 months that passed in between where he's promoted and given accolades about his work?
Certainly, Your Honor. So when we're looking at causal connection, we look at direct evidence of discriminatory animus if we're just talking about age discrimination, and then indirect evidence, which can be proven by close proximity or temporal proximity. When we're dealing with just direct evidence, we've alleged it. In paragraphs 5 and 22 of the complaint, there are the allegations that there are multiple meetings in which the CEO of the company and Mr. Lively's direct supervisor is making a sequence of age-related remarks in which he is stating that WAFRA needs to replace older employees with younger employees. On its face, that's discriminatory. That is showing a favoritism and an inference of favoritism and disparate treatment for younger employees over older employees. It also is tying in age to a negative outlook on the future.
Am I right that your client was replaced by someone who was older than him?
Yes, Your Honor, that's not.
And how does that assist you or not?
So it really is inapplicable at this stage?
Oh, it is absolutely relevant, okay?
Certainly
you
is.
can't say, I was discriminated against because of my age. I lost my job just because I'm an older guy, and then they hire an older guy.
Certainly, Your Honor, and just to take that apart a little bit, just piece by piece. So first, but for causation.
I would suggest to you only have about a minute left. I wouldn't take it apart piece by piece, just answer my question.
Yes, Your Honor, so under Stevenson and Meary, it's not required to be pled. It's actually not even the standard that you have to be replaced by an individual who was older. As Justice Acosta stated.
But it's certainly indicia that goes against your claim of age discrimination.
Certainly, but that's again engaging in a plausibility analysis of the claims. We're at notice pleading. We're not at motions for summary judgment, and this is not a McDougall analysis. It's merely whether or not the claims have pled sufficient facts to state a claim. Any cognizable claim from the four corners of the complaint and all inferences in Mr. Lively's favor. By engaging in that kind of analysis, we're moving into the federal standard, which is exactly what the SDNY and the Second Circuit.
No, we don't want to move into the federal standard because it's very different than the state and local standard. But still, these negative statements, and you said several times, but we really don't know the times. We just know it was in the summer, I think he said, in the summer. Yeah. That's very vague. And we don't know what statements, who they were made to, or anything with regard to that. So those are very vague comments. And I think the other one was really what we might think of as an offhanded comment, where he says to the son of the person, hey, we should hire you instead of your father. I mean, because you're younger, we should hire you instead of your father. That doesn't really sound like something that's a serious comment. But I still don't hear the causal connection between these statements that you say were made sometime when we really don't even know to whom or when, and how it relates to his firing, which they say clearly was because of the sexual harassment.
Certainly, Your Honor, and the sequence of statements from the summer, that's 5 and 22 in the complaint, are paired with the culminating statement, which is the November 13th, 2017 statement. And I would respect—
The statement, the paired with the November statement to the son.
Which was in front of Mr. Albadir, who was a coworker of Mr. Lively's, as well as in front of Mr. Lively.
That's the only place where there is specificity, where there is any information about what happens. The statement to the son, oh, we prefer you, the son, over you, your father. Who would make a statement like that other than in jest if they really wanted somebody to take it to heart? I mean,
Well, as we have alleged, Your Honor, Mr. al-Mubaraki had engaged in conduct like this that the HR individuals, Mr. Padron, was complaining about actually when Mr. Lively went and complained of. So Mr. al-Mubaraki would be the type of person who would make that kind of comment in serious nature. And the sequence of events culminating with that specific comment can also be tied to the pattern of discrimination that was existing at the same time. So in the
I'm glad you brought that up because I was going there. So I'd like to know what, if any, allegations were set forth regarding this effort to terminate the other older employees, and how did that relate to the plaintiff's termination?
Certainly, Your Honor. So as is stated in the complaint, it began around the same, about 2 years preceding Mr. Lively's termination, which is around, I'd say, 6 or so months before the comments in the summer.
Right.
And those individuals were all in their 50s, 60s, and 70s. Mr. Leary's example, I know we cited in our opening brief, is a near perfect parallel to what happened to Mr. Lively. And that is that Mr. al-Mubaraki made a comment to Mr. Leary in which he says, "You're too old for this."
No, I know that, but I'm not sure if you're really answering my question. So I want to know, what, if any, allegations are set forth regarding these actions? What were the circumstances regarding the termination of these older employees?
Well,
Point me to the paragraphs.
Certainly, Your Honor. We don't make any, besides the Leary allegation, we don't have any additional specifics. However, we don't need to. That is not a pervasive, we're not alleging pervasive pattern. We're not alleging that is direct evidence of discriminatory animus. What we're alleging is that it's a pattern of discrimination, as Justice Acosta said in his Melman dissent. It is indicative of the employer's state of mind. And actually,
but that's not here where they're not even similar. In those cases, in the cases of the comparative employees that you use, there's no sexual harassment. There's nothing to put that into context here.
well, Your Honor, and I apologize for interrupting. In the DeCintio case, which I understand is a Second Circuit case, there's gross misconduct found in the intervening period between the discriminatory remarks, the protected activity and the ultimate termination. And in that case, the actual Second Circuit said that on summary judgment, it was that there was enough facts for it to go to trial. And
Anyway, I'm going to let you finish on. I've given you a lot of extra time. Let's hear from the other side. You finish up on rebuttal.
Oh, yes, ma'am. Thank you, Your Honors.
Good afternoon, Your Honors, and may it please the Court. Brett Tannenbaum from Paul Weiss for defendants, respondents Wafra and Fawaz al-Mubaraki. I'll be brief and just respond to the points that Mr. Zona raised and that the panel raised. First, with respect to this weighing of the McDonnell-Douglas burden-shifting framework, whether there were factual inferences that need to be resolved, it's not so, and I would just like to take Your Honors through the allegations within the four corners of the complaint that make very clear on the face of the complaint that no city or state law discrimination or retaliation claim has been pleaded here. So with respect to discrimination, the alleged age-related comments, and Your Honor is correct, there were two. There was a series of unspecified comments in the summer of 2017, unspecified meetings to unspecified attendees along the lines of, Mr. Lively and others are too old, I should replace them. There was also a comment in November of 2017 to Mr. Lively's son. No other recipients or people who heard that comment were actually alleged in the complaint. And then there is nothing. There is nothing until the termination, which occurs more than 5 months later, and by Mr. Lively's own allegations, follows an April 2018 complaint of sexual harassment against him. That's at paragraph 7 of the complaint. And it was immediately preceding his termination, again, by Mr. Lively's own allegations. He was made aware of the complaint, he was interviewed about it, and then he was terminated. And the stated basis for his termination, by Mr. Lively's own allegation, was that complaint. So you really don't need to get further than the complaint to conclude that he hasn't set forth any evidence or any allegations of discriminatory animus. On retaliation, the timeline also works against Mr. Lively by his own allegations. So he says that he reported Mr. Al-Mubaraki's comments in and around November 2017, or maybe a few weeks later. But then there is nothing. In fact, in his briefs, Mr. Lively argues that the nothing is what was threatening and retaliatory, and therefore can be connected to the termination. And I'm not sure he cites a case for that or that I've ever seen one. But the fact that he
nothing.
Right. He reported it to two employees of WAFRA. That's alleged in the complaint. And he alleges they didn't do anything. He doesn't allege that they were decision makers with respect to his termination. He never alleges that Mr. Al-Mubaraki, who he does claim was a decision maker, even knew about the reporting. And then he has his allegations of, well, there was a complaint made. He was interviewed about the complaint of sexual harassment, then terminated. And
that complaint included not just verbal accusations, but documentary evidence.
Correct, extensive
of the plaintiff sending inappropriate notes to coworkers.
Correct. That's correct, Your Honor. And this was evidence, by the way, that was authored by Mr. Lively himself, which he deliberately omitted from his complaint and then asks this court to credit the allegations without that evidence and give him a chance to get evidence, to get discovery on his claims. This is not the type of sympathetic plaintiff for whom the city statute was revised in 2005 to protect. He's had more than his day in court, and he's never alleged sufficient allegations to state these claims. Thank you.
Thank you, Your Honor. So beginning with just the knowledge piece, so the actual allegation is that Mr. Lively did report this to the CEO of the company. It's a fair inference and a favorable inference that should be drawn in Mr. Lively's favor, that first, the COO and the CEO do speak, especially when an allegation against the CEO of the company, as well as Mr. Lively's supervisor, takes place. It also is a fair inference that human resources would communicate such a complaint, seeing—
This is all that you're just saying. We don't have any evidence of this, right? This is not documented anywhere. You're just saying, oh, that happens.
No, Your Honor, this is in the complaint. I mean, it's in the complaint that that Mr. Lively also went to the COO of the company.
Yes, but you said, and it's common knowledge that these, they talk or...
Certainly, Your Honor, and I believe it's a fair inference that could be drawn from the four corners of the complaint that a CEO and a COO...
What can be drawn from the four corners of this complaint is that there was a serious allegation against your client for sexual harassment that occurred before he was fired, and that is what he was fired for, the culmination of that. And yet, what I still don't hear, what I still don't see from the complaint is the causal connection between his firing and these statements, many of which were just vague, which you still haven't been able to articulate for me. And the one that, if you want to say that it wasn't, that he made to the Sun, I don't know who else was there, but he made it to the Sun, that's still 6 months before without any connection in between.
Well, Your Honor, there were other individuals there. I believe the complaint alleges that Mr. Al-Badir was present, who's a PIF, the parent company of WAFRA, an executive there. And Mr. Lively also was there because he heard the complaint. As far as...
Okay, but this is sort of like, the petty slap. This is just, it's not something that amounts to the significant kind of allegation that is intended here. Oh, my son versus my, hire the son versus keep the father.
Your Honor, respectfully, the statement is almost a perfect parallel to the statement made in the Martinez case. Understanding it's a Second Circuit case, and in that case, the plaintiff English, who actually had her claims go forward, she was told that all individuals who can retire should retire to make room for the younger generations.
But was
And
that
she didn't-
followed?
sorry.
I mean, the other problem
Sexual
here is
harassment?
temporal proximity. There was a huge gap in time between those two comments and when he was fired, but no gap in time at all between the sexual harassment claims against him and being fired. So I don't see how you've explained that.
Certainly, Your Honor. So as far as temporal proximity, now temporal proximity it comes up in both contexts, right? So it comes up in the discrimination context as well as the retaliation context. This court in Thomas v. Mintz held that 6.5 months was a sufficient was sufficiently temporally proximate to sustain claims for retaliation. In the Harrington NYPD case, a 7-year interval between
But that would be, sir, but that would be without an intervention of a sexual harassment claim that he acknowledged in the complaint.
In the Dicentio case,
We
Your
can
Honor.
have a gap in time, presumably, if there was nothing else, but this was front and center. And there was a federal action brought against your client by the victim here, the coworker, and he settled with the victim in that federal complaint.
Certainly, Your Honor.
And this is in the face of your client saying, I did nothing wrong, in the face of what my colleagues raised were actual documentary evidence to show that he was writing inappropriate, or sending inappropriate emails to his coworker who was a subordinate. It is the classic sexual harassment scenario. That's very different from the line of case that you're referring to.
Well,
I think you are hot as a firecracker, and it makes me happy to see you smile. And sometimes you would get flowers and jewelry with that. So what do you say about that?
Certainly, Your Honors. So the Second Circuit in Dicentio held that I believe a year or 8 months was sufficient with gross misconduct in the intervening. So temporal proximity there has been found to be sufficient. And as far as the facts that have been submitted by defense, this is engaging in the plausibility analysis that was done, and this is not a motion on the pleadings. It's a motion to dismiss. Therefore, and the Second Circuit actually went very heavily into this in correcting the SDNY and finding the SDNY had erroneous analysis when it engaged too much in a plausibility comparison as to which was more plausible, whether it was the sexual harassment or it was what was alleged in the complaint, whether that is age discrimination or retaliation.
Thank you. Thank you both.
Thank you very much, Your Honor.
Yes. People versus Keith Woody.
Good afternoon, Your Honors. May it please the Court. Daniel Cook, intern at the Office of the Appellate Defender for Appellant Keith Woody. The trial court erred when it admitted unnecessary and highly prejudicial evidence of Mr. Woody's 2-year-old conviction for attempted criminal possession of a weapon. First, evidence of the 2-year-old gun charge was not necessary to explain the police response because none of the approximately 100 police officers who responded to the scene were aware of Mr. Woody's prior conviction. The officers responded to the scene because they had heard the radio run indicating that Mr. Woody was possibly armed, but they didn't have knowledge of the prior conviction. And given that over 100 officers who responded had no awareness of the conviction, it simply wasn't necessary to explain their conduct.
But didn't the court allow this because the defense opened the door and said that they were going to cross-examine on this and were going to sum up in a particular way on this? And then I think, was it stated in the opening as well, I think?
Well, Your Honor, the court admitted the conviction relying on People v. Santana, essentially on an assumption that defense counsel would open the door at trial. And while there is a factual similarity between the facts of Santana and the facts of the case here, the reality is that Santana was not about admitting Molyneux evidence. Again, it was about admitting evidence after the door has been opened on cross-examination or during opening.
Yes, but I'm saying, didn't the defense here open the door by saying that they were going to do the cross-examination and that they were going to sum up on this issue?
Well, no, Your Honor, because during the motions and limine hearing, the defense counsel, in challenging the admission of this evidence under Molyneux generally, was essentially put on notice by the court through its exploration of the case law that warrants excluding the evidence and its discussion of the potential arguments it could make as to police propriety, that essentially its strategy at trial could open the door to bringing in this sort of evidence.
When was the first time this was raised? It was at the Molyneux hearing before the trial, correct?
Correct.
And did the defense attorney at that point say that he was going to be using this to go to the propensity of the officer during the cross of the officer?
Defense counsel indicated that they might take the route of challenging the propriety of the police action on, say, cross-examination of Detective La Femina, but as a consequence of the hearing, defense counsel was put on notice that that strategy would risk opening the door to bringing in that evidence. So what defense counsel, essentially what the trial court should have done in this situation is exclude the evidence as was required by Molyneux and its progeny, and then wait and see what defense counsel's strategy at trial was. Because now the defense counsel was properly apprised of the risk of admitting this evidence, defense counsel could tailor its strategy appropriately to avoid opening the door. But instead, because the court made this ruling at the motions in limine hearing, defense counsel was essentially locked into a strategy where it would challenge the propriety of police action, and it would do so in order to effectively rebut the admission of this prior gun charge.
Now, the propriety of the police action, as you said, the officers who descended on the scene were not aware of his prior gun conviction. Am I right? Is there any place in the record that establishes that?
They were not aware of the prior gun
There was no radio run by this officer who claimed to see a bulge that appeared like the outline of a gun.
There was, Your Honor. All the responding officers had was this radio run indicating that Mr. Woody was possibly armed, and Detective La Femina indicated that he made that broadcast because he had observed this bulge. And so for the responding officers, the prior gun charge simply didn't explain their conduct and wasn't necessary to explain it. Now, as far as Detective La Femina is concerned, his individual actions were also entirely explained by other evidence that the jury heard. As far as the bulge is concerned, La Femina testified that he broadcasted that Mr. Woody was possibly armed because he saw the bulge, and images of the alleged bulge were shown to the jury so that they could evaluate that for themselves. Additionally, as far as why Detective La Femina stopped Mr. Woody, that was explained by La Femina's testimony that he stopped Mr. Woody because he had a parole warrant, as well as the lengthy and damaging testimony that the parole officer Grissom gave, indicating that he didn't have, in fact, have a parole warrant.
He did not?
That he did, in fact, have a parole warrant.
Did have one.
Yes.
And the parole warrant was due to his absence from meeting with the officer, right? It wasn't a new charge. It wasn't a new arrest, commission of a crime or anything. It was that he failed to report.
That's correct, Your Honor.
Okay.
Good afternoon, and may it please the court. Jillian Lewis on behalf of the people respondent. Your honors are correct that the defense counsel did open the door during the hearings and indicate that they were going to be relying.
That was a question, not a statement.
Correct. You were correct in your questioning that it was true that the defense counsel did, during the hearing, state that they were conceding the fact that he had a parole warrant out for him at that time, and that the court looked based on the forecast, the court said, of the information that was going to be presented, and decided that it was important information for the jury to have when considering that information.
Didn't the court jump the gun here by excluding that or including, allowing that information, that testimony, before the defense asked the question? In other words, a defendant doesn't have to put on a case. They don't have to prove a case. They don't have to do anything. So as things unfold, they may decide to take a different tact. That was taken away by the judge saying, well, we're going to allow this. I mean, they might not have done it at all.
Well, Your Honor, the defense indicated initially that they were planning on questioning La Femina and the other officers about that conduct. And additionally,
but again, the problem is that as my colleague has just stated, by making the ruling and admitting that evidence that normally would not come in unless the defendant took the stand, okay? Because this is actually more in the nature of Sandoval, right? This is a prior conviction.
Well,
And under Sandoval, that's not supposed to come in unless the defendant takes the stand. So defense was not even permitted to adjust their strategy here.
Well, defense isn't arguing Sandoval, they're arguing Molyneux, and
I understand that, but I'm saying, by the judge making this ruling, it prevented the defense from switching gears. They now did not have a choice but to go after the police officer's actions.
I have another to add to that. Did the prosecutor or the defense speak about this in the opening?
Yes.
Statements?
Yes, and
Which one? The prosecutor spoke about the fact that you would hear that there was a conviction for a gun?
And that there
in the
was,
opening?
yes, and then that there was a belief that there was a bulge, but there was no objection at that time. And
But that is because the judge already said you can do that.
correct, and that ruling was limited. It was limited to the fact that he had a warrant out because of a gun-related charge, and that was the only.
No, he had a warrant out because he did not report to parole.
But then he was told they were told he had a conviction for a prior gun.
For a prior gun, correct. But
So-
that information was necessary for the jurors because.
Why was it necessary when you already had evidence, with respect to, seeing the bulge, knowing that, he had the prior conviction? And I have another question. Why was this necessary when we know that the other officers didn't have that information about the prior conviction?
So this was necessary twofold because of the response.
Right,
of
100 officers.
And-
I mean,
and-
that's a whole nother issue.
And the hearing court perfectly articulated why this was necessary because of the reading of Santana and Reza.
Because a police officer a police officer that says on a radio run, pursuing a man who I believe is armed isn't enough. Why is that not enough? This officer says, I see a bulge, the bulge has the outline of a gun, and so I'm gonna pursue him. Why is that not enough?
It sounds like we would have 100 officers all the time based on that, given what happened here.
Well, it was not enough. It explained and further clarified La Femina's belief that he had a gun and the proximity in time. La Femina.
So propensity.
Not
No, because you're saying, well, since I know he has a prior for a gun, and I am claiming I see a bulge that looks like a gun, I don't understand those two. I don't understand why that factual recitation by this police officer, I observed this guy crossing the street, he has a bulge in his pocket, and the bulge looks like a gun, so I pursue him. I don't understand why we need to know, why the jury needed to know that he had a prior for a gun other than propensity.
And Santana explains that. It shows that in that case, there was a dangerous, authorized, high-speed chase. Here you have officers responding, and it's the middle of the day in July. There's a lot of people on the street, and they're pursuing the defendant, and it explains the rationale for why La Femina, who throughout trial and throughout cross-examination is...
But again, the officers any officer, based on the description given by this officer, I see this guy crossing the street, he has a bulge, and the bulge has the outline of a gun. They don't need any more. That's more than enough to pursue this guy. And he didn't need to say anything else to engage other officers in this pursuit.
Correct.
So I don't understand why the jury had to be told He had a prior gun conviction, by the way, on this chase where the police thought he had a gun and, oh, by the way, found none.
Because the defense counsel revealed during the hearing stage that this was going to be their theory, and they allowed, instead of when La Femina, who was their main witness who initially encountered the defendant, got on the stand to make that determination, the judge was within his authority at that hearing stage to make that determination.
Yeah, but you know, the judge, go ahead. The judge is required to do a balancing test here to sort of weigh this, and that's really what we're getting to the heart of here, because it was certainly enough information for the officers who were out in the field to know they needed to get this person. Why? Because there was a parole violation, he didn't show up, and he had a bulge in his pocket that looked like a weapon. Don't know, but those two things were sufficient to get 100 cops to follow or look for this person. So why at trial did there need to be this additional piece of evidence to defend the credibility of the officer, which is the only thing I can see? It was to defend his credibility, to give the jury more. And they did that by attacking the propensity, that went to the propensity of the defendant, because, as my colleague has already said, if you already have enough for the cops to follow, certainly jurors can follow. This is a guy, not a good guy, if I saw what I believe to be the outline of a gun in his pocket, who had violated parole. But now on top of that, we're adding a piece that this defendant had a conviction for a gun. So now we're telling the jury that they are to believe the officer because this defendant already had done this on another occasion. That goes only to propensity. So even though there's this, I think there was a limiting instruction, the limiting instruction did absolutely nothing because there was only one way the jury could have viewed that evidence. Only one way. Propensity. That's exactly what the judge said. It went to the credibility of the officer, and it was used to show the propensity. This guy, he had a gun in the past, so when the officer says that he had a bulge, you better believe it was a gun this time, so you go. So the limiting instruction is a non sequitur. It did nothing, because there was only one thing that jury was charged to do with that evidence.
But, Your Honor, there's no charge here for a gun. So it's not...
I understand that. I don't mean charge in that way.
No.
I'm saying the jury was told this man had a conviction in the past for a gun. Am I correct?
But that doesn't...
So he's telling the jury, why do they need that? Other than to think, oh, well, all I know now is that this officer saw a bulge and this person violated parole. Oh, that's not enough. Now I need to know that defendant has a prior gun conviction. So now that's only saying that, okay, the officer, it goes to show that he had a bulge now, he had a gun before, he's got a gun again. That's the only thing it goes to.
But there's no propensity to possess a gun, because that wasn't one of the things that the jurors were charged with finding.
Except that's what he was chased for.
That's the...
So the fact that you didn't find one and therefore couldn't charge him with one is, to me, of no moment.
But the
jury
propensity
was being chased for a gun.
The propensity goes to the jury to show this is a bad guy who had a gun then, and the officer is credible because he's saying this guy who he knows had a gun already has a bulge now. That bulge is really a gun. That goes to the propensity of the defendant.
Your Honors, the evidence is overwhelming that during the pursuit, he entered an apartment with young girls that one of them testified.
You know what? The fact that during this chase by over 70, 80, 90, 100 officers, that he should be in an absolute fright and flight mode to make sure he doesn't end up dead, okay? That he would run through construction sites. There was no intent to go and commit a crime inside that construction site other than to avoid being arrested.
You
So
started,
that's how we got here.
you were making a statement, you didn't quite finish it, and it was that we went into someone's apartment. But what were you going to say there?
Which the jury found and he was charged with. And they also found that he was resisting arrest. And the
Okay.
But he would
The
never have
resisting
done that if
arrest-
he hadn't been chased by 100 police
That's right.
officers.
The resisting arrest and the resisting arrest and the running from 3 officers, the one plus I think there were 2 others, that's one thing. He's charged with burglary because, as my colleague said, on both sides, he's running like crazy now because it's not 3 officers. It's 100 officers, as you said, in broad daylight. 100 officers because somebody has what we think could be a gun. I mean, I don't know what population of New York City, if you have 100 officers coming out all the time. I don't know. It just is crazy. And he runs into an apartment only to get out. He didn't stay there for tea. He didn't stay there for, he wanted to get out as fast as he got in. So you were saying that he's run through all these buildings. It was only for that purpose, to escape. He didn't hide there. He wanted to get out a different way.
Your Honors, because of that overwhelming police response,
yes,
the lower court, the hearing court here, relied on Santana and Resnick to make that determination that this information was necessary to explain that response and to explain the police's...
There's nothing that could explain that response because it was completely irrational, unreasonable, and unnecessary for this. And so now they want to put it on a defendant by putting in evidence that goes to propensity. The guy is not a good guy. He's a bad guy. We know he had a gun conviction. He now didn't go to his parole officer. Jurors aren't stupid. That, in a test way, sounds like that should have been enough. Anyway, thank you very much.
Thank you.
Thank you, Your Honors. Unless there are further questions, appellant rests on the arguments in
You
their
don't
brief.
want to say anything about Santana?
Sure.
I'm just giving you the opportunity.
Sure. Well, the people rely on Santana for the admission of this evidence, for the idea that it was necessary. The problem, though, is that first, defense counsel couldn't have opened the door pre-trial when, through vigorously objecting to admission of this evidence under Molyneux by probing the limits of the court's ruling, the court couldn't have opened the door there, and it should have waited to see how defense counsel approached trial once it was on notice that this evidence could potentially come in. And the evidence wasn't necessary where the door hadn't been opened, but also the jury was presented with the bulge information underlying the parole warrant. And here, none of the 100 officers who responded to the scene were aware of this and were aware only of Detective Lafamina's radio run, where the prior conviction's purpose here was to essentially present the jury with the propensity inference that because Mr. Woody had a gun before, he had a gun now. That was, on these facts, was incredibly prejudicial and was the sort of thing that would have compelled the jury to look past the elements of the offense and to convict regardless, and was wholly inappropriate.
Thank you. I heard you say that you were an intern?
Yes.
Where are you at school?
I'm at NYU.
I'm sorry?
NYU.
Oh, very good. You did a great job. Both of you did an excellent job, and I recommend an A. If anybody's here listening.
Thank you.
Okay. Thank you very much. Thank you both. 4720 3rd Avenue, Housing Against CA Ventures.
Good afternoon. May it please the court, Chris Georgioulis for the appellant. This case, the lower court, in analyzing a 3211 motion, did not use the correct legal standard.
Counsel, I have a very simple question.
Sure.
At what point is it your position that the parties had a contract?
On August 8th, 2018.
And where is that, where does the record support that there was a contract on that date?
It's in the complaint, and it's in the affidavit of William Cody in both. And under 3211, that's sufficient. There's an allegation, and those allegations must be deemed true. It goes far beyond, it's just not a simple allegation. It tells a very specific story about exactly what happened, who they met with, how many times they met, what was agreed to.
But then how do you square that with the fact that in April of 2019, they signed a joint venture terms sheet which explicitly said that it was non-binding and subject to the execution of definitive agreements? If they executed a contract in August of 2018, why in 2019 would they say something totally to the contrary?
It's not contrary. It's actually consistent, because the term sheet that you're referring to, Your Honor, involves the second part of the deal. The first part was A and B. My client with CA, we're going to do a deal where we're going to build and develop a property that's owned by a third party. That part was not yet consummated. It wasn't finalized. So when the two of them, they were going on for months, the agreement in August was made, and pursuant to that agreement for 8, 10, 12 months, they're going forward. 95% of the design documents had been accomplished by that point.
And are you claiming that's a written agreement in August of 2018?
No, it's an oral agreement, but they're both pursuing it, and you can see the trail of emails. There are architects, engineers, project managers, many people from each side working on a weekly and actually daily basis in putting the design together. What was holding up the deal was the fact that there wasn't a final agreement with the owner, Cactus, that owned the property. And that's where the frustration was evident through those emails with my client, because it wanted to finalize the deal with Cactus because they were spending a lot of money. And there was no question that if you look at an email on October 17th,
I'm glad you said that, because that's where I was going. Because
Sure.
I was under the impression that October email only addressed the proposed equity contributions that was set forth in that November 2017, I'm sorry, letter of intent, and it really had nothing to do with any payment of the pursuit cost.
Your Honor, that letter of intent that you're referring to in 2017 didn't involve my client. My client doesn't get involved until the summer of 2018.
Okay, but let's go back.
It was a different party, totally irrelevant.
Okay. No, but let's stick with this email, because did it concern any payment of cost there, the pursuit cost?
No, what had happened, and in the complaint, and in the affidavit of Cody, who explains, he was both the general contractor, he was going to have an equity position, he agreed to do the pursuit costs early. When they finalized the closing with Cactus, then part of his cost would go part into the equity, and then CA Ventures would contribute whatever it owed. Now, that email of October 17th involves a proposed modification by CA Ventures, where they're saying, okay, I want to modify this because they wanted a little better position. In exchange for that, I will pay those pursuit costs immediately, shoulder to shoulder. And in fact, in that same email, they talk about the original deal and referencing the general partnership that they had already formed. And let's not forget, the decision of this court, of the lower court, was as if this were a summary judgment motion. This wasn't a summary judgment motion. This was a 3211 motion. And the decision actually was made based on A7, failure to state a cause of action. But whether it was A7 or A1, individually or collectively, that application should have failed, because the court is tasked with, look at the complaint. Within the complaint, is there sufficient cause of action that's recognized? The answer to that question is yes. Documentary evidence under 3211 has to be, it absolutely has to utterly refute any of the allegations. Well, that's not the case. In fact, those emails that the judge, in fact, the judge made an evidentiary finding, and he says it straight out in the hearing transcript.
You just wrap up because you came to an end.
I'm sorry?
Just finish up your
Oh,
thought
yeah.
there.
So he actually made an evidentiary finding, a finding of fact, which is totally not allowed under the Rovello Court of Appeals case. Says that's not something that the trial court should do on the 3211 motion.
Thank you.
Good afternoon. May it please the court. My name is Damon Sudin of Kelly, Dry, and Warren for the defendant respondents. I think Your Honor was correct to point out the term sheet from 2019. In that term sheet, the plaintiffs admit, it's Mr. Cody who signs it, admits that the plaintiff will bear the pursuit expenses up until the time of closing, when the defendants would then true up the expenses, I think is what it says. It also points out that there's no binding agreements, that the parties are still negotiating, that nothing will be final until it's in writing. And
So the
plaintiff has
question
argued,
the question is, if it was definite in August 2018, why would they have then entered in the term sheet that made it seem so indefinite?
right, I think
Saying that's the question. That's the thing that's puzzling here.
right, if they already had an agreement, an oral agreement, he claims, in the summer of 2018, then he wouldn't have said, Mr. Cody would not have signed something in April of 2019 that says there is no agreement, we're still negotiating, and by the way, we're going to pay the pursuit expenses until we get to a closing. And of course, this is, well, one other thing, the plaintiff has argued multiple times that somehow this term sheet is with other parties. The only two people who signed it are Mr. Cody and Mr. Thompson, the same people who have been negotiating all of these details for the better part of a year. And by the way, the term sheet is also consistent with several emails from Mr. Cody where he admits exactly what was said during these conversations. And the key one is from January of 2019. It's on page 79 of the supplemental record, onto page 80. And in that email, Mr. Cody says to Mr. Thompson, you told us CA will not put one penny into this deal until we close, have a building permit, a GMP, a completion guarantee. We get that, Mr. Cody says. We just need a guarantee from CA that if when we get there, you will be as well. So I think it's clear in January of 2019, it's unambiguous, there's no refuting this, that CA told him, Mr. Thompson told him that CA would not pay one penny into this deal, which it completely undermines the allegation in the complaint that Mr. Thompson not only told them they'd give a penny, but millions of dollars in pre-development expenses, whether or not the deal closed, that they were just going to pay that money. That clearly didn't happen. It's completely undermined by Mr. Cody's own words. And this is, again, consistent with on the previous page where he says, we need to know CA is on board, responsible for costs. Obviously, he didn't know they were responsible for costs in January of 2019.
He keeps raising different questions about what's going on.
Right, exactly.
That one would not expect if the deal was signed, sealed, and delivered, or at least that there was a meeting of the minds and it wasn't an agreement to agree.
Right, that's exactly right, Your Honor. And the same is true in Mr. Cody's email of December 2018. This is page 73 onto 74 of the supplemental record, where he says again, we actually did have a discussion on the timing of CA funds, and you made it clear not until closing. And then he goes on to say, we made it clear we have no problem waiting. And now they claim in the complaint that they've already agreed to this in April of 2018, that these costs would be paid whether or not they went to a closing at all. It's completely inconsistent with the documentary evidence in the record. The court below looked at all this evidence. I think the hearing transcript bears that out. And he said repeatedly that the overwhelming evidence refutes the claim. I think he applied the right standard under either A1 or A7, and I would ask the court to affirm.
Thank you.
Thank you.
I would like to quickly address the actual exhibit, the term sheet, which is found in R111. That contemplates, if you look at the second paragraph, several joint ventures. CA Ventures wanted certain things in the agreement between the owner and the general partnership. And it was it just confirmed what was originally agreed to between my client and CA Ventures. The emails do not utterly refute the allegations. In fact, as I've said, they are consistent with the position taken by my client. The fact that there was the second deal was taking so long, Mr. Cody was totally frustrated that he was going to lose the deal. And it's in those emails. He keeps talking about Cactus and Ishkenazi, which was the principal of Cactus, that we're going to lose this deal. That was the frustration. They wanted to finish the deal because they were going to lose it. And he had expended all these funds, and the fact that he was only responsible for 45% still added to up to over $1,200,000 at that point. And he was concerned because they weren't putting up their land deposit that they were required to do. They were just absolutely not complying with all of the terms that they agreed to, which are set out in both the affidavit and the complaint. And this is a 3211 motion. I would just like to leave the court with one item. Had there been discovery and a deposition to Thompson, and he was asked that specific question, did you make an agreement on August 8th in the office of Mr. Cody, where you shook his hand that you had an agreement? And if he says yes, everything that's said by the respondent would mean nothing because an agreement had been reached on that August 8th date. Thank you. And everything else is in our papers.
Thank you. Thank you both. Tender Touch Health versus Nudzeg.
May it please the court, Avram Turkel, Borstein Turkel, PC for the appellants. Regarding the argument on vacatur, I'd just like to go straight to Ms. Swan, appellant's expert witness in the arbitration. Ms. Swan had written a report in 2019. That report went to the underlying billing of Tender Touch to Newzig and 300 Broadway.
You have, you're going to this, I want to let you have your argument, but you have a very heavy burden here. There's no judicial review, really, of an arbitration, even if there's a mistake of law. And here we have just, facts that the judge, not facts, but determination that the arbitrator, these were there three rabbis, had the ability to make. And presumably, the three of them came up with a rational choice to not have, virtual or not allow this person to come back and testify about the money. And really, was there a dispute of the money? I mean, they already had sought, to the claims for that money. So this is not, these are not the kinds of reimbursement I meant for the money. So this is not the kind of issues that we have the ability to review.
Your Honor, the court does. The court has it does under 7506. So one form of misconduct is refusal to hear evidence that is pertinent and material. Right? The report was was submitted or attempted, in the words of Tender Touch, they tried to submit it.
But arbitrators
it went to
do you disagree that arbitrators have a huge amount of control over how they run the arbitration? We do we do not generally micromanage how arbitrators run their arbitrations. And it seems to me that you're asking us to do that. What would allow us to do that, given the very high standard for overturning an arbitration decision?
Well, it is in Goldfinger, which Court of Appeals Goldfinger case. I mean, it clearly is the purview of the courts to have some say over the arbitration body's conduct of the arbitration. The arbitration body can't.
Only in very extreme cases. Can you tell us of any case where the exclusion of one witness who chose not to appear was a basis for overturning an arbitration, especially where the parties had specifically agreed on this mechanism of arbitration and had chosen the arbitrators themselves?
No, but I think the facts of this case are unique, right? I've seen many cases where the courts have allowed the arbitration bodies to conduct virtual hearings during the pandemic. The court said that was all okay.
Counsel here. What they want. But the point is that we cannot impose our will on how they are to operate their arbitration. And this court has been reversed on cases where we have tried.
Under the specific facts of this case, the
point you to bolt.
Thank you, Your Honor.
I just want to follow up because the arbitration agreement gave the Bethton authority to follow any procedure that they wished. in-person was required. This is not a situation where testimony was excluded. The bottom line was in-person was required. And if I'm not mistaken, I don't think you provided enough notice, with respect to setting up any remote proceedings. And certainly, I didn't see anything where you, how can I say it? You made any offering to make any arrangements with respect to remote proceedings.
It's an interesting point, Your Honor. I ask you to look to the affidavit of Mr. Epstein from Tender Touch. There is no dispute that the report from Ms. Swan was entered to the Beit Din. There is no dispute that Tender Touch gave this sort of preventative testimony concerning their ability to reform billing by memory. Maybe they didn't need to have doctors' signatures on that billing. What was not allowed, what was not provided for, was an opportunity for that report to be entered by appellant, by Tanuzig and 300 Broadway's witness. And what Mr. Epstein
But it was
says,
received in evidence, right?
I'm sorry, Your Honor?
The report was received by the arbitrator, right?
No, I don't believe it was. What you have is in Mr. Epstein's, we say it wasn't. Mr. Epstein says they tried, that is to say, Tanuzig tried to enter it as evidence, and the only thing that prevented Ms. Swan from testifying and submitting that evidence was the panel's refusal to follow any protocol. I just ask you to look back again at Mr. Epstein's actual language. His language is, we didn't provide notice. How could we provide notice of a date for her testimony if the panel had not made a determination that it could be virtual, that it would be in perhaps a place that had...
Thank you. You can finish up on rebuttal.
Thank you, Your Honor.
Good afternoon, Your Honors. My name is William Dorsey of the firm of Blank Rome, and I represent the respondent, Tender Touch, in this matter. This, as you've already noticed, is a confirmation proceeding of an arbitration that was held by 3 rabbinical court rabbis pursuant to a proceeding that was agreed to by the parties. There was a combination that was put out as to the submission of evidence, and the report was considered by the rabbinical court. There were a couple of issues here. If you look at the record, there was an attempt to make a Zoom option available for the witness, and as we pointed out in the affidavit, there was also a trial by ambush problem where this repeatedly, the appellant in this case tried to put in evidence without giving notice to the other parties. There was an attorney that was called. As the evidence shows, the only requirement was that I be allowed to be there, the attorney for Tender Touch, to be able to rebut that attorney, and so that nobody was excluded. They were all allowed to come, and there was even a discussion about Zoom options. They never happened. But the other more important...
Sir, would it be fair to say that as long as there's a rational basis for the decision, that's all we need? Fair?
Absolutely, and that's what
so on this record, as we understand it, I'm going to use a round number, say approximately $710,000 worth of bills submitted by Tender Touch, which they sent every month between 2016, 2017 to 300 Broadway and then to New Vista during that whole period, were submitted to either the federal government or to private insurers, and all those bills, the very same bills that are an issue, were willingly turned over and paid on, correct?
Absolutely.
And that is really the rationale for this Beit Din or rabbinical court. They basically said, it really becomes a non-issue to deal with the so-called irregularities as to whether the accuracy of the billable hours and all that other stuff, when everything was fully paid for, and you, New Vista, are in possession of our money. Fair?
Exactly. Said it much better than I did. Thank you, Your Honor.
Okay.
With regard to Judge Schulman's point about the rationality of the award, it's not on the record that, in fact, all of these payments were made, et cetera, on insurance. It's an allegation. It's reading into the really brief decision of the arbitrators. What we do know is that the witness that appellants had, Tanuzig and 300 Broadway, that would show that the billing was not due, right? That money was not due to Tender Touch was precluded because the panel in January of 2021 would not allow for either a remote or a COVID-safe environment for a expert witness who, as you see the affidavit, is in cancer remission and needs it. There are also evidence of ex parte communications between the so-called or supposed neutral arbitrator, Rabbi Eichenstein, and Mr. Epstein. Again, if you look at Mr. Epstein's affidavit, Mr. Epstein doesn't deny that, right? His affidavit says, well, I didn't have any, I don't recall any communications that were about material and relevant things. He doesn't deny the ex parte communications. He just sort of massages the issue. That should have gone for hearing before Supreme Court. This should not have been decided on summary confirmation. Tanuzig and 300 Broadway were denied their opportunity for a fundamentally fair hearing in the arbitration. There are also issues regarding the third-party VistaCare, 5225. 5225 is for judgment debtors and judgment creditors within the context of an Article 75 proceeding, special proceeding. It's unavailable at commencement. It should have been dismissed. And the same under the DCL, along with our arguments for jurisdiction.
Let's talk about the ex parte communications, because, I mean, there was just a claim that they learned that from Rabbi Stern, but that's certainly hearsay, and that wasn't that Tender Touch's arbitrator, choice, right? I'm sorry, let me just do this again. Yeah, that you learned from Rabbi Stern, but that's hearsay. What else do you have?
About the ex parte communications, there is a we were told that there was an email between the Tender Touch claimants and the panel. What we suggest to the court is that this should not have been determined on motion without a hearing to determine whether or not to get some discovery and to determine the credibility of the witnesses, given the actual affidavits of the witnesses, and particularly on the issue of the witness preclusion. That witness testimony, along with a report, which I understand was not actually submitted to the Beit Din, was integral, was core to the issues before the Beit Din. It was not incidental. Thank you, Your Honor.
Thank you both. Siegel versus Eisner.
Are there three of them?
Yeah, there are three. I was surprised too.
Oh.
Yes. Must have heard me. Yes.
Thank you, Your Honors. Alex Bine for Appellant. I'm here to introduce my colleague Emil Hirsch of the DC and Maryland bars, and I respectfully request that Mr. Hirsch be permitted to appear and argue the appeal.
Yes, I will allow the motion, but I will say, to quote our colleague, Justice Angela Mazzarelli, who will shortly be leaving us, be retiring, that we have thousands of excellent lawyers in this district, in the department, so, but we will be gracious and allow argument here from you, sir.
Thank you, Your Honor.
Thank you, Your Honor. My name is Emil Hirsch. I'm here as a counsel for the appellant Karen Lehman Eisner. The appellant's principal and global point in this appeal is that Judge Edmead had equity jurisdiction as well as equity power.
Counsel, I have a question. At the time when Ms. Eisner filed her order to show cause, that was after Judge Edmead had dismissed the petition in the underlying case. What was left of the case in which it was appropriate to make a new motion? I mean, if the new motion had been to re-argue, that would have been one thing, but why was it appropriate for a new motion to be made when there was nothing left of the underlying case?
Well, Your Honor,
I guess the question is, why didn't your client follow Judge Edmead's advice in her earlier decision and file a new proceeding that would have had to have a petition setting out a claim which the order to show cause lacked.
Your Honor, we moved for leave for Judge Edmead to allow us to file. Had
You
we
filed an order to
proceeded-
show cause, right.
Right.
And I'm trying to understand why you believe that there was anything left of the underlying proceeding, given that she had previously dismissed it.
Well, she dismissed it without prejudice.
Right, she dismissed it without prejudice to your filing a new proceeding. That was what the underlying order said, the dismissal order.
Well, Your Honor, there is one particular aspect of Judge Edmead's decision that I think kept the case alive from a technical standpoint.
So I'd like to see where that
I'd like
appears.
to
Her
explain to
earlier
you-
decision appeared, I believe, in the supplemental record. I didn't see anything in the supplemental record that kept anything alive.
In her original decision, which I call Edmead number 1, which is in the supplemental record.
Yes,
You will
and
note
which she
that
said.
she did two things.
She dismissed it without, she dismissed the petition for dissolution, quote, without prejudice to petitioner's ability to bring another proceeding, should deadlock in fact later arise. But this wasn't another proceeding, and I don't see that she left any door open to resume, to come back before her in that proceeding. Could you show me where in her decision?
Yes, Your Honor, I'd like to address that very
Love to hear
point,
it.
because I've gone over that just the other day.
Good.
She said two things about the counterclaim, and this is important. It goes to the fact whether there was a final and appealable judgment. And I submit to you that her decision, which is the SR, was not a final and appealable judgment. It was a judgment on fewer than all claims for two reasons.
Right,
One-
okay, good. But I just read you part of it where she said it's dismissed without prejudice to bringing a new proceeding. Where did she say anything inconsistent with that?
Well, first, she did not enter judgment on the counterclaims. She does, if you look at the decretal paragraph, where she enters judgment, yes, on the main claim,
What
which is
counterclaims?
Siegel's claim, she dismissed that without prejudice. But she has to dispose of the counterclaim as well in order to make that a judgment on all claims as opposed to a judgment on fewer than all claims, and that she didn't do. And it may be a reason why Mr. Eisenberger, who has...
We don't have in the record any evidence of counterclaims in the original proceeding, I don't believe.
Well, Your Honor, there is a long
And it also, her
description of it.
decision says case disposed. That didn't leave anything very open on page 1 of the supplemental record.
But Your Honor, starting at SR 10, there is a description under Roman numeral 2, Eisner's counterclaims. She says at one point that before she gets to SR 12, which is the prayer for injunctive relief, she says that in light of her disposition of the petition for dissolution, which brought that proceeding on, the counterclaim is moot. Whether that's right or wrong doesn't really matter. But if you notice that in the decretal paragraph at the end of the SR, she does not dispose of the counterclaim.
Except that she says on page 10, while Eisner's counterclaims are moot, as the court finds dissolution of the foundation is not warranted, the court briefly addresses each of the counterclaims below. So it seems to me that everything that comes after that is dicta. She's already found the counterclaims to be moot.
I'll let you answer that briefly, and then you have rebuttal.
Well,
I'll give you 30 seconds to.
I suspect that I don't know this for a fact, but I suspect that one of the reasons why Mr. Eisenberger, on behalf of Barbara Siegel, did not appeal that decision, and it's not just because he was a dismissal without prejudice where they can renew their petition at another time, but it's because it did not have, I think, the finality that you need to have when there are multiple claims, including counterclaims. And
Thank you.
moreover, the other point...
Thank you. You can make that other point. Yes.
My name is Jeremy Shockett, and I represent the respondent. Your Honors, I just want to point out three things that appellant is seeking. The first, they are seeking to have the lower court's factual and legal determinations thrown out. That's their right to ask. The second, though, is they're asking this court to disregard the statutory framework of the nonprofit corporation law, which this case started under Section 1102. And in appellant's original brief, except for the caption, they never address Section 1102. And the third thing is, even if this court were to get past those first two, they're asking the court to basically make a determination for which set of directors to choose, and they're doing it they're asking without the lower court having made those factual determinations, because the lower court did make fact-finding. They found that our client, Barbara Siegel, didn't act inappropriately, didn't commit fraud, had good faith reasons for rejecting directors, and I'm not casting aspersions here and saying that appellant was fraudulent or did anything inappropriate. The court said this wasn't ripe for dissolution at the moment and gave leave to renew, which appellant says Sheldon Eisenberger had a different reason for not renewing it. Tactically, whatever. It really doesn't matter. We're the respondent here, not the appellant. It's a very high burden for the appellant to get over to ask this court to disregard the statutory framework of the nonprofit corporation law, which this case is squarely on. And one more thing before I go. Their brief and their reply brief repeatedly say that dissolution is equitable. Therefore, you should grant the remedies we're seeking. They are not seeking dissolution. They never did. In fact, their order to show cause was done to, quote, remove the specter of dissolution. They can't have it both ways. They can't ask this court to make an equity decision based on dissolution and then say it's not. And the final thing before I go is equity. If the court were to get to equity, which I submit you shouldn't, but if you did, equity is a gap filler. The cases they cite, which frankly we agree with, equity is a gap filler. For instance, they cite a case where there was no New York statutory right to same-sex marriage. However, marriage is equitable. Therefore, the court had the right to fill that gap with equity. This case is statutory. It's based on the directors not agreeing, the corporation not being able to function, and not being able to do its business. Therefore, our client moved for dissolution. The court didn't grant it, they left it open, and they allowed us leave to reapply. If the court doesn't have any questions, I'll turn it over to rebuttal. Thank you.
Your Honors, it is amply demonstrable, and I don't want to repeat something that I've said at length in the opening and the reply brief, that dissolution is not a remedy at law. And this is a false binary that the brief of the respondent introduces in this case, that a judge in equity in this state—
Are you now claiming that you're seeking dissolution?
We were not seeking dissolution.
Okay, I just wanted to get that clear.
No, we consistently opposed dissolution, vehemently then, but this is a third attempt where, in the guise of a collateral attack on Judge Edmead's initial ruling, okay, they're trying to bring in the possibility of a dissolution. It's a false binary, honored justices. The trial judge in New York, who has ample equitable powers, is not limited to this false binary of doing, just because there's a deadlock, of doing nothing or dissolution. This is a clever attempt to focus this court's attention on dissolution. This appeal is about whether she had equitable jurisdiction, unquestionably she did, and equitable powers, which come as inherently with equitable jurisdiction.
But there was no petition in front of her. There was no proceeding in front of her because she dismissed it.
But she gave—
So, and your order to show cause Like if there's a dismissed complaint, as you would understand, one would say, okay, I move for certain equitable relief and to reinstate the underlying petition so that I could seek equitable relief. But I read your order to show cause, and again, it was reframed with the judge's own criteria of no reply and various other things, when she initially filled the order to show cause. But the problem here is there was no proceeding in which to sign an order to show cause for. You would agree with that?
No, I will not agree with that, respectfully, Justice Shulman, because we asked for leave. When we asked for leave, there was an underlying representation that there was still a dispute which would be cognizable as a head of equity jurisdiction because it related to the governance of a New York charitable corporation, and we asked her for leave to file in that. Had we not asked for the leave, I would agree with you wholeheartedly. The reason I can't agree with Honor Justice, what you said, is because we pointed out to her that there was still a live controversy. It was not over dissolution, but it was over a related ancillary matter that had post-dated the dissolution.
Thank you.
We asked for leave, she gave it to us, so I think it is jurisdictionally live as equity subject matter. That's my whole point. Had we done it with...
Thank you, counsel. Thank you. I think we've got the point. Thank you both. The next case, Widcom versus Con Ed. Justice Gessmer is recused from.
Wait, you forgot Sanford.
It was.
Oh, Sanford's just submission?
Submitted.
Okay.
It's okay.
Afternoon. I know it's late in the day, so let me try to do the best I can to sort of get to the point on the issues in this case. My name is Alan Russo of Russo and Gould. We represent the appellant and respondent, EGK. I keep on saying EKG, EGK in this case. Getting right to the point.
Yes.
What we're seeking in this case is a reversal of the lower court's decision, which searched the record. Nobody moved for summary judgment against my client on either on common law negligence nor on a violation of Rule 200 of the Labor Law.
But how you're asking for us to find in your favor on the common law negligence and the statutory 200. Am I correct?
No, I'm arguing in opposition. I represent the defendant who was this court. Yes, I want you to reverse the lower court's decision. And let me point out to the
That's why I said find in your favor.
Yes.
Yes. Yeah, but I'm asking how can we do that when there are questions of fact with regard to whether this is, it's open and obvious, but whether it's inherently dangerous. Aren't those questions of fact that we can't reach?
Under the facts of this case, I would say no, and primarily based upon the circumstances of this case. The alleged inherently dangerous condition is a board that...
Yes, I know. I looked at the pictures, and he rose too soon. He
rose too soon.
And he hit his head. So you can see that the board is there. He knew it was there, but isn't it inherently dangerous? Because it's like that kind of thing that you see, but you don't see. You know it's there, but because, of the way it's put in there, you can,
Well, no, I don't think it's inherently dangerous because it was there for a reason. And it's an area that's not
I don't think that's in the case law about whether it's there for a reason. I mean, something can be there for a reason and be inherently dangerous, can't it?
Well, I don't think it was inherently dangerous under these circumstances. This is not a place that was heavily traveled. It was a small building with only 3 units in the building. This was a...
But what would that have to do?
Was this the only way to access this area where this gentleman had to work?
It was, well, there was another way, but would have had to gone through a tenant's apartment, which was in the basement. The
superintendent's apartment?
Correct. And
who gave him access to this truncated area where he has to climb through, basically.
He didn't have to climb through. He was
Well, you
able
can't
to,
walk standing straight through there, can you?
he could bend down.
Exactly,
which is
so
what he
you have
did.
to bend down, okay?
Okay.
Going in and coming out, right?
Correct.
Okay.
Correct.
Most of us don't have to bend down going through doors. Usually the door is tall enough for us to, our body to fit through it.
But there are circumstances where maybe the door or the doorway is not tall enough because of a reason. And this particular reason was he had been, our
I understand,
client-
they had stolen pipes from this area, I get it. So he
and
wants to safeguard his building,
Correct.
and in doing so, he creates this makeshift area to guard against people breaking in.
Correct.
But then anybody who has to go in there now has to deal with this obstruction.
So I still don't see how what you're saying makes this not inherently dangerous, which would be a question for the jury. Why doesn't this rise and fall right there? What can we do?
Well, what you could do is reverse the lower court ruling that found it inherently dangerous and negligent of my client as a matter of law. It's a jury question.
Yes, I agree with you, it's a jury question.
So we're seeking a reversal of that. And then on the issues of the statutory violations, I mean, my goodness, this is a real tortured interpretation of the New York State labor law. I think the people who drafted...
Sir, you're talking about 241-6 and whether this is a sharp projection.
Correct.
And it's your view that this board, with the kind of edge that it has, is not what that regulation was designed to address?
Correct. And it did not involve a tripping hazard or a hazard on the floor. Which,
And in any event, your client isn't a traditional labor law defendant, correct?
Correct. They didn't
He was
contract
forced
for-
to give access to determine that gas leak.
Correct.
So he would be out on 241 and 241-6, correct?
Correct. Okay. That's our position in the case.
Okay. Thank you.
Anyone have any other questions?
I think not.
Okay, thank you very much.
Thank you. Okay.
Good evening. May it please the court, Michael Zhu, appellate counsel to Morgan, Levine, and Dolan, attorneys of record for the plaintiff, Michael Whitcomb. I was going to lead with the 200, but Judge Renwick, I hear what you're saying, that there's an issue of fact. I was going to argue that there really is no issue as to whether it was inherently dangerous. This was a board that had a sharp edge. The plaintiff testified, and Angus Hastings stated in an affidavit that as he rose up, he cut himself and he was bleeding. So that, I believe, refutes any claim that this was not inherently dangerous.
I don't think that makes it inherently dangerous, but
I hear the court. I hear the court. So I'll address the statutory claims. As to the EGK's argument that it's not a statutory owner, I would submit that that's wrong because under Court of Appeals decisions in Abatiello and Sanitas, and this court's decision in Rhodes, the second department's decision in Otero, dealing with utility workers, in Rhodes here, a Verizon worker was given access to the defendant's property to perform work. And this court held that under those circumstances, that establishes a sufficient nexus between the ownership of the property and the worker being there to establish labor law responsibility.
Yeah, but there wasn't the work to install
For a
lines,
tenant.
cable, or whatever.
It was for a tenant.
Right.
Had nothing to do with the owner of the building. Same thing with Otero.
Yeah,
In
but this
Otero
was
versus
work
Time Warner.
outside, there was a gas leak outside, they had to find it. I mean, they had to let them in no matter what, gas leak.
No, but the meter was inside the property.
Yes, I
So-
understand.
So it's not a situation where,
You think they could have said, we're not gonna fix the gas leak? I don't think in New York City you can say, I'm not fixing a gas
of
leak.
course not, no, and that's not the
You had
argument,
no
Judge.
choice here.
And that's not the argument. The argument is he was given permission to come into the property. He was given, the super had a key to open a door
Yes.
to come in. So it's not as if the worker just came in on his own to perform the work. As to...
It's a closer issue.
I'm sorry?
It's a closer issue
Yes.
than the other one.
As to the 241.6, the violation of the 23-1.3, on 1.7E, I would submit that there's no issues of fact as to whether this was a sharp projection. The defense experts...
It's not a projection in the way that
sorry.
it's meant by the statute.
Well, but the statute doesn't say, and you have other cases dealing with issues of sharp protrusions that cause injuries. For example, there's a case, I forgot the name of it, I'm sorry, that dealt with a worker who lacerates his hand while going through a door, and he gets cut on a sharp glass, 23-1.7E. The Lopez decision in the Second Department, where the worker impales himself on a rebar as he falls onto the ground. Didn't trip over the rebar, he impales himself because it was a sharp projection.
That is a sharp projection.
In a third case from this court, I forgot the name of it, it's in my brief, it talks about a U-channel, right? A worker trips, he doesn't trip on the U-channel itself. He trips and falls and hits his hand on a U-channel that cuts his finger. Sharp protrusion. Anything that's capable of cutting and puncturing is a sharp projection. Doesn't necessarily need to cause a trip and fall because the regulation protects tripping and other hazards, and which is exactly what we have here. As to the 240 claim, we believe that there's a violation of the statute because the staircase itself, which was the sole means of access to the work site, is a safety device, and the safety device here failed to provide proper protection to prevent the plaintiff from falling. He gets up, he hits the back of his neck, and he's caused to fall onto the staircase. This court in Connellan, which Judge Renwick and Judge Manzanet both sat on, in that case, the plaintiff trips and falls over an extension cord.
Very different case because the work was on the stairs and he fell in going down the stairs to get other work done. So that these stairs here had nothing at all to do with the job of turning off the gas. Gas meter wasn't right there, had nothing to do with it.
But the court in Connellan said even if it just involved the tripping and had nothing to do with the work on the staircase, because it said...
He didn't trip on the stairs. He got up too hard. He hit his head up there.
And he fell.
This had nothing to do with the stairs. He didn't trip on the stairs. He wasn't engaged with the stairs as a result of, it was what was above him.
Well, no, I would disagree with that because he also testified...
Okay, you can disagree.
I'm sorry, the plaintiff testified that it wasn't just hitting the neck on the board, the excessive height of the staircase itself, it was 13 inches that caused him to misstep, and the lack of a railing. He testified that's what caused him to fall as well. So it wasn't just the board itself, there was specific defects in the staircase. I see my time's up. I'll save the rest for a rebuttal.
Okay.
May it please the court, John Fabiani for Respondent Con Ed. I said I would be 4 minutes or possibly less. Previously, this court heard oral argument about a criminal case in which you discussed Santana. I would actually like to quote another musical icon, Rod Stewart, and that is that every picture tells a story. If you look at the pictures on page 929 of the record, I think that you can see that 240, a label of 240 is in no way implicated in this case. Plaintiff hit his head and he fell down onto a concrete floor that had between two stairs. The only other point I would like to raise is that with regard to 241.6, Mr. Zhu pointed out in his reply papers that my client did not appeal from the denial of the motion to dismiss the 241.6 claim. Under the Canning case, if Mr. Russo's client's application for dismissal of the 241.6 claim is granted, then the claim against my client should be dismissed also, and that is within the power of this court to do it. So, less than 4 minutes. Thank you.
Thank you.
Just very briefly, echoing what Mr. Fabiani just stated, the plaintiff in this case did not fall down. He fell up, actually, onto the steps. So, I mean, this is clearly not a 240 case. And what is amazing to me is He made a motion of summary judgment under these facts under 240, didn't move under 200 or under negligence against my client. And what does the court below do? It finds negligence in violation of 200 and ignores and it does the right thing on 240. It was just sort of ironic the way this whole thing came down. Thank you very much for your time and patience this afternoon.
Thank you. Didn't somebody have rebuttal here? Wait,
I'll
wait,
waive
gentlemen,
my
you're going
2
too
minutes,
fast.
Judge.
Okay, thank you very much. Thank you all.
Let me clean this up real quick, and then I'll tell you what time we're gonna.
We need to, you just straighten it up, or?
Huh?
What do you?
Just throw out that trash.